numbers of two applications in the post title of the order dated 7th July 2023 has been incorporated as IA number CAN 3 of 2023 and IA number CAN 4 of 2024. Italics a single inverted comma. In place and stead of quote unquote IA number CAN 3 of 2025 and IA number CAN 4 of 2025. Stop. Office is directed to effect necessary correction.
Well, my lord, I am appearing for the respondent. I believe there is a typographical error. I believe, my lord.
What is the problem if it remains? What is the problem?
Your lordship mentioned, my lord.
Lordship, I have mentioned the matter. There's a typographical error in the name of the learn. Yes,
My lord,
বলে দাও তোমরা এই সকালবেলা এসে টুটে এম্বারেসড হতে হয়
I have
বলে বলেও
put
শেষ
the orders for you. নামটা ঠিক
by reason of a typographical error in the post title of the order dated 2nd July 2025. The name of the learned senior standing counsel.
Yes, your lordship, Mr. Shishwanu Bandopathyay.
The learned senior standing counsel has been incorporated as quote unquote Mr. এটা বলে দেবে in place and stead of quote unquote. Where is the spelling?
The spelling? I have given the spelling to the red court officer.
স্পেলিংটা দাও না আবার ভুল করবে office is directed to effect.
Your lordship, if I may indicate, the name also is recorded wrong on the order dated 25th June
Let us
2025.
merge with this order. What is it?
I'm grateful to your lordship.
no, all the three matters, ma'am. All the three matters, 4, 5, 6. 4, 5, 6, my lord.
কতগুলি আছে
To 6.
একসাথে আছে
শীর্ষচন্দ্র বন্দ্যোপাধ্যায়ের নামটা ভুল আছে।
I thought it was something serious. It's a correction matter. I'm in 5 only. That's why.
we have just corrected the name. Yes.
For the appellant.
দেখি কি বুঝি কার নাম
Yes. Yes, what instruction?
My lord, I am for the respondent number 1 to 4, my lord.
On the last occasion,
Yes, any instruction you obtained?
My lord, instruction I have received, my lord. My lord, the thing is, my lord, I have got the payment, entire payment schedule, my lord, I have brought. So far, my lord, they have paid. Total amount, my lord, paid by them is 11,84,000 till now. The loan was. My lord, may I hand over a schedule, my lord, of the payment schedule? I have got 2 copies of the same.
page 28,
Duto ache, na?
109.
My lord, even, my lord, during the sub period, my lord, from 2006 to 19, the lordship, my lord, finds, my lord, that the payment, my lord, the EMI for every month, my lord, that was not paid, my lord. Some 2 months skipped, sometimes 3 months skipped. All these things, my lord, happened.
Yes.
Thereafter, my lord, 11,84,405 that has been, my lord, totally paid.
990.
Wait. What was the total loan amount?
Total loan amount, my lord, was 17,50,000. 15 lakh initially, my lord, sanctioned. After that, 1.5 lakh. After that, again, subsequently 1 lakh.
On 3 different dates.
3 different dates. Therefore, my lord, totally 17,50,000 was the total loan amount.
17,50,000.
50,000. Now, my lord, what has happened is subsequently, my lord, we had preferred an arbitration proceeding to recover that amount, my lord, before the Assistant Registrar of Cooperative Society, my lord, who is acting as an arbitrator under the provisions of, my lord, the Cooperative Societies Act. Now, my lord, an award has been passed after, my lord, repeated service upon of someone, my lord, upon the, my lord, the appellant hearing. An award was passed on 30th of April 2025. My lord, the service of, my lord, this service has been, my lord, satisfactory service has been recorded. After that, the award has been passed for recovery of 22 lakhs 22,000.
Award was passed.
Award is passed, my lord.
22 lakhs.
22 lakh 22,314. Award has been passed on, my lord. The date is 30th of April 2025. My lord, this has been passed, my lord, by the Assistant Registrar of Cooperative Societies, who is acting as an arbitrator. Now, my lord, again, after the award was passed, my lord, again notices were served upon them, my lord, to recover that amount. No response from them. We have been, my lord, constrained to file an execution application. Money execution case number such and such, my lord, which is, my lord, right now pending before, my lord, the City Civil Court. While, my lord, the appellant hearing is, my lord, appearing before this honorable court in a writ petition and, my lord, subsequently in an appeal. My lord, before the learned arbitrator, my lord, they were, my lord, absent, my lord, on repeated occasions. My lord, summons was served, my lord, they never appeared, not contested the my lord, application itself, not contested the arbitration proceeding. Subsequently, my lord, we are constrained to file this execution application. And, my lord, it has been specifically recorded in the award that, my lord, the penal interest, my lord, that has already been, my lord, foregone. We are, my lord, leaving aside the penal interest itself. What has, my lord, been recorded, my lord, by the impugned order itself.
So why didn't you tell the single judge? This fact was not pointed out, but the award amount was recorded. 22 lakhs 22,000, that is there in the order. You
Yes.
were not there before the single judge.
I'll just, my lord.
You did not disclose that there was an award before the learned single judge.
Read petition was moved in the year of 2024. That is subject matter challenge before your lordships.
Well, the award is
The
subsequent.
appeal is pending before the honorable division bench, and it was mentioned several times.
So you did not participate in the award proceeding. Writ petition was filed earlier.
Earlier.
After
Thereafter,
that, the award was
against the order passed by the Honorable Justice Amrita Sinha. whether it is REIT is maintainable or not.
You
I-
did not tell them that an award proceeding is pending. Court was not apprised of this fact that an award proceeding was pending. How can we help you?
I haven't knowledge. I've made several approaches before the authority concerned.
Mr.
To
Taha,
one
you were
time-
served notice, there was an award.
If your lordship, my lord, so pleases, my lord, I can, my lord, put this on record, my lord, by way of an affidavit, my lord.
So, Mr.
The award-
Banerjee, is there any possibility that
My lord, my client has specifically, my lord, instructed one thing, my lord. My lord, 2006 to 19, my lord, irregular EMI we have received. Now, my lord, 19 onwards, when my lord, in discussions where my lord started to, my lord, when my lord mediation, my lord, we were on the verge of my lord having a discussion, notices were sent to them. At that point of time, my lord, no response. Only, my lord, and already, my lord, penal interest has been foregone. My lord, the penal interest, my lord, is amounting to almost, my lord, about 10 lakhs have been, my lord, let gone. After, my lord, the award has been passed, the execution case has been, my lord, preferred. Only after that, my lord, the appeal has been, my lord, listed and
no, you were saying from 2000 to 16 to 19,
19.
loan was of 2006.
6 to 19, my lord, 6 to 19. 2006 to 2019.
Regular EMIs were paid.
No, my lord, that is why, my lord, I pointed out, my lord, my lord, provided, my lord, the payment details.
Page 20.
Your lordship, my lord, kindly sees, my lord, that,
Then you put it on record.
yes,
You
yes,
also-
I'll do it, I'll do it. I'll do it.
18th February, 18th October 2020 তারপরে তো award,
The petition to pending. Award amount. The dispute, no, dispute case was not contested by them.
No, no, no. Ex parte order was, my lord,
So, Mr. Banerjee, total loan taken was
1750.
17 lakh 50,000, my lord.
for that he has already paid 11 lakh.
11 lakh 84,405.
So, if that calculation goes about 7 lakhs due.
7 lakh from the principal amount, if we, my lord, consider the principal.
Yes. 7 lakhs due. So you will
5
take
lakhs.
years to get this
55,000.
money execution settled.
Lordship, this I, my lord, I am my lord, a creature of instruction. My lord, my lord, what is passing through your lordship's mind, I have already, my lord, communicated that. That if a middle point can be reached, my lord, kindly, my lord, they are of the opinion that already, my lord, the penal interest, which is, my lord, statutory provision, that has, my lord, been foregone. And my lord, that is recorded in the award itself. That was also, my lord, recorded in the order impugned, my lord, before the learned single judge. 1 to 4.
5,65,000.
Yes, there nothing remains in the appeal there.
He approached the authority concerns one time measure. Kindly, I'll pay some amount of money.
Not some amount, you have
That
to
is, I have taken instructions.
try to
9
appreciate
lakhs.
that there is an award on 22 lakh.
Beyond my
Now
knowledge,
that
otherwise
award has not
it is
been
beyond my
challenged by
knowledge.
you. Try to understand. That award has not been challenged by you. So
Okay.
we cannot help you anything in this appeal. But if you say that I am going to pay this amount, we can ask him and to settle the thing.
Yes.
Otherwise, it cannot be done.
It is not within my knowledge.
Uh-huh.
Otherwise, it is not within my knowledge that
It cannot be- it was knowledge of your client, maybe he has not furnished it.
we are totally helpless.
ওটার loan ছিল কি তোমরা?
সেই arbitration proceedings এর ভিতরে
কম্পিউটার করে 3টে ব্রেকআপ বেরিয়েছে।
award হলে award
যাই হোক উনিশ অব্দি 11,82,000 টাকা পেয়েছি। নয় 82,000
হ্যাঁ মানে স্যাটিসফ্যাকশন এটা রেকর্ড
একটা 15 কথা
plus it can be
But
considered.
we are trying to help.
Yes, it is beyond our knowledge.
No.
Otherwise, I'll not.
You see, if they go into execution,
Yes.
they'll sell off everything that you have and try to recover the maximum. Give a figure which is reasonable, at least, you know, they can also agree because they have an award in hand.
At a time, she can pay 10 lakhs at a time within 3 months from the date.
And then pay some in installments.
No, at a time within 3 months.
10 lakhs
The
is
husband
Yes.
has Parkinson.
Acute,
Parkinson
the appellant is suffering
Parkinson
acute
illness,
Parkinson disease.
and the wife has
That is last stage.
income,
And
income
the
source.
wife of the petition appellant is a
some installments.
housewife. This is the
If you can
problem.
scale down a bit, you know,
sympathetic considerations. Otherwise, I have not
out of
legitimate claim.
17 and a half, they have paid 1180.
11 lakhs have been paid.
This is helpless
No, no, I'll
pleading.
take I'll take install.
Otherwise, you see,
It can
you will not really get that 22 lakhs. Let's look at it on a very
at a time.
realistic. You'll not be able to recover the 22.
Only, my lord, only appreciates only one thing, my lord.
I fully appreciate. That's why. So I just see how much you can.
My lord, I'll take instruction.
That are in some difficulty, but Mr. Shah, you also try and see how much you can go up because
Yes.
Max.
otherwise, perforce, we'll have to dismiss the appeal.
When is the date fixed before money execution?
This is, my lord, on 9th of August. Next week.
9th of August.
That should be 3 for the time. 9th August is for it.
Against you, award you have not challenged, execution case proceeding, unless you give a substantive amount question, because we also cannot interfere. It is a award passed in terms of the
I have
statute.
any knowledge. Otherwise, I'll not.
That is not
appear
believable
before
because
judges.
award wouldn't have been passed without service of notice. Moreover, the award must have been collected
Intimated
upon
my
putting
claim.
signature.
There's a fault on the part of my client.
You place your calculation on record.
Yes, yes.
If you and they will use a reply and settlement, if possible, they will agree to.
My lord,
Otherwise, law will take its course.
my lord, I'll do it. But I'll try and convince them, my lord, if my lord, middle point can be reached at all. My lord, I'll do it.
Mr. Banerjee, learned advocate, appearing for the
Great.
My lord. My lord.
My lord, service is incomplete, my lord. Only 2-3 days time to complete the service, lordship. Kindly. Fixed it to Friday, lordship. It would be completed
Next Tuesday.
next Tuesday. Great.
Item number 9, my lord, the state is the appellant. My lord, the Learned Advocate General has requested me if my lord kindly fixes this sometime next week, subject to your
Who
lordship's
is your oth- you are who is your oth-
I am in 14. I'm
Yes, 9 and 14.
9 and 14 are different matters, my lord.
But
9 and
in
14 are
both,
different matters.
Learned Advocate General is appearing and he has requested me.
কার্তিক কোন দিনটা একটু ফাঁকা আছে না?
Any day subject to your lordship's convenience.
ক্যালেন্ডারটা বার করো না।
21-22 ক্যালেন্ডার চলে।
In 14, my lord, a case has already been started. My lord, this is the matter wherein a special investigation.
Students,
Yes, my lord. Students were tortured inside the police lockup, and my lord, a special investigation team was
No, we
formed.
have not passed any interim order.
No, my lord, no interim order was passed. Our humble prayer will be only a report, if can be called for, how much the investigation has been proceeded
No, we
till
have asked the Advocate General to produce the FIR.
my lord, my
Which
lord,
has
my
been done. So we keep it on 29 July.
29th July. Yes, my lord, my lord.
The 9 and 14, 29 July. But you kindly wanted the Advocate General to bring that FIR,
FIR, not Quera.
whether you were there or not.
No, I was not there.
So
আচ্ছা এগুলো কিন্তু সেপারেট ম্যাটারস না
tell
একসঙ্গে
him
ট্যাগ
to
করবেন না
call that and place it before us. There is also an direction. to
Will
that.
it be my lord's pleasure to even invite the case diary to be produced or only the
No,
FIR?
only the FIR will do it.
our humble prayer will be my lord how much the investigation has all been proceeded so
Mr.
far.
Chatterjee,
My-
they are challenging the very decision itself. We will decide the matter. If we
My-
hold in their favor, we will call for documents. Or if we hold in your favor, then the entire episode ends.
Grateful man, great.
29. March. মনে রাখো।
Yes.
Appellant.
Service complete.
Yes, madam.
14টা একসঙ্গেই হয়ে গেল তো ডাক হবে না তো আর?
Episode matter. Where is the bank?
A bank appeared before the trial court, and also sub notice they have received. They have received, only one return back, but the branch manager and the bank has received. But what happened in this petition was that the petitioner opened two fixed deposit in the year 1982 in the Punjab National Bank, Jakiria Street branch. Now, in the year 1983, a fraud was committed in the bank. A CBI inquiry was directed to conduct. The branch manager, others of the employee of the bank, including the petitioner and other customers, are arrested and accused in 1983. Now, my two fixed deposit were not liquidated since the entire process was under the investigation of the CBI. My fixed deposit was taken into the bank. In 2024, the CBI, the trial of the said offense was completed, and I was declared acquitted, honorary acquitted. Then I paid before the bank. I return my fixed deposit with the interest. That has been the challenge for the trial court. On a single
They have
judge,
given simple interest to you.
but only for the 1 year. I made the fixed deposit in 1982. It was due to lordship the mature in 1983. I have been given interest for 1982 to 83. Since 83 to 2024, but nothing has been paid.
So why didn't you approach earlier?
But I have approached.
Was there any order freezing your account?
Nothing, no order. Bank has simply, if you also can see the impugned order once, paragraph 6, page 2. But the submission of the petitioner that the higher rate of interest and the interest at the prevailing rate for the period of the bank withheld amount mentioned in the fixed deposit received ought to be paid cannot be accepted. The fixed deposit could not be repaid because of the legal complications. The bank cannot be held responsible for the delay in conclusion of the legal proceeding. Now, my entire fixed deposit was kept with the bank. This is not the case. The bank has parked the amount in a separate account without an interest fee account. They have used that my money for their banking purpose, for their business. You will have to kindly see the breakup given by the bank to the honorable single judge. That is in my application, page 160. 15th May 2024.
When was the proceeding initiated?
In the year 1983.
That is after your maturity or prior to maturity?
After my maturity.
Why didn't you seek for disbursement? Your fixed deposit was for how many years?
For 1 year.
So very good. The proceeding was initiated after 83. You could have taken the money at that juncture. Problem.
If you kindly see, my fixed deposit was opened 14 September 1982, and FIR was lodged on. Give you the exact date, my lord. Written complaint was of 18th September 1983, and my lord, the FIR was of my lord, 20th August 1983. My maturity was of 14th September 1983, just 14 days before.
In fixed deposit, either you have to take it back or you have to give a mandate that
But if you also kindly permit me, I can produce the notification of Reserve Bank. It says, in case certain, suppose not I have a fixed deposit in a particular bank for a limited period, for 1 year. I did not give mandate to yes. But as per the notification of the RBI, the said fixed deposit will be auto-renewed for 5 years consecutively.
That we don't know whether that was there in 83.
But
that
thereafter,
is the system now.
Thereafter, the simple interest will carry. Initially 5 years auto renewal.
Mr. Ghosh ascertained in 1983. Nowadays, what happens if you don't give that mandate? Automatically sent over. It is continued. You cannot take it back after that, but it can be continued.
Yes.
For say, in the meantime, they obtain a mandate from you.
Yes, it will continue for 5 years as per the recent notification. Thereafter, it will carry the simple interest.
But how will you explain of non-furnishing mandate? Moreover,
It is admitted
83
fact. It is admitted fact from the allegation was of there's a fraud. There's an allegation against the branch manager that he has defrauded the bank money amounting to rupees almost 1 lakh at that point of time.
That's the branch manager. You. How was the petitioner?
Allegation was that the branch manager transferred certain money in my account also. That was the allegation.
Did you ask for return of the money once it matured on
Yes.
15th of September?
Yes, this was asked for, but unfortunately that was not annexed in my application, but the copy is with me. That is copy with me. I applied, it's on 5th July 1983. Requested them kindly return back my money.
5th July. But your maturity was of 9th September 1983.
Before maturity, I made the application because I need the money. Kindly allow me to.
that was not told to the learned single judge.
That was not placed. Yes, rightly it is not placed with the learned trial.
The single judge proceeded on the basis that there was no mandate towards.
Admittedly, when I'm not given any mandate, it was only the request to kindly allow me to withdraw the money. It was a request. Admittedly, there is no mandate.
After due date, when the petitioner asked for repayment, was not paid on the ground that a criminal proceeding is pending.
Cost of old record activity.
Even for the sake of argument, if I accept that if I don't give any mandate to the bank, I'll not get the actual interest of the fixed deposit, but I am entitled for the simple interest.
After 40 years, you are making this.
Number kindly consider
25. You could have, before the criminal court also, you could have availed of the opportunity. When the investigation that for the investigation, then secured that amount, you could have asked that if there is an allegation of fraud, my amount which is in the these disputed things, how can we go into after 40 years, Mr.
But this is not, but kindly consider whether the money has been used by the bank. This is not the case that bank has been kept the money in a interest fee account, or they have not used for their business purpose.
They have paid you 44,000 and
yes, they have paid.
5,000.
They have paid me
Just
55,000 and odd. 55,308 against the fixed deposit of
40,000.
40,000. Or may I serve notice for the notice and come back?
Thursday week. You have the affidavit of service?
Yes, madam, I have already filed.
Ashok, affidavit of service, has filed be kept. the memo was served.
Memo. Only the application was served. Memo was not served.
Then you come on Thursday. Let us see if they get it and come. Then
I shall serve simply notice that communicating your lordship's order.
the petitioner, the appellant.
Much obliged.
For the
My opinion,
respondent,
Lord, one thing I'll just indicate, Mr. Ghosh wouldn't be aware, Lord, the writ petition has been allowed, setting aside an order of declaration of fraud. Similar such orders was passed because a consortium of bank had declared the account of the petitioner as a fraud account. That was set aside because it was contrary to a Supreme Court judgment and a coordinate bench judgment of this honorable court. One such appeal had come up before your lordship on the last occasion. Lord, this was the order that your lordships had been pleased to pass because there was no scope for an interim order. I'll give him also a copy, my lord. He wouldn't know about this. Same, your lordship will find. The petitioner, writ petitioner is the respondent here. Second paragraph, my lord. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are of the opinion there is no scope towards issuance of an interim order. Appeal needs to be heard finally. In view thereof, the appellant directed to requisite paper books that your lordship will consider, my lord.
2 minutes, my lord. I'll take 2 minutes of your lordship's time before my lord, my learned friend is quite.
There is a delay also of 84 days.
84 days. I have filed an application on section 5, my lord. I've explained the delay at paragraphs 4 to 8. If your lordships are pleased to consider the application, my lord. The section 5.
Section 5 opposition.
Appeal has been preferred, alleging the present appeal has been preferred, challenging, and what is the date of the?
The order is dated, my lord, 25th of February. 25th of February, 2025.
They can make a memo of appeal.
Paragraph 3 to 5, your lordship will consider.
Challenging in order dated position.
No, my lord. It's their writ. We preferred an appeal.
So all the documents are here.
Yes.
Any further document to be relied?
No, my lord. I do not think we need to rely upon because their.
আমার তো কোনো extra document
on their own documents, it's admittedly shown, my lord, that they had the documents which were not brought before the notice of the court.
Upon hearing the learned
the memorandum of appeal will be served on us. No order will be required separately. I'm sure they'll.
Mr. Ghosh, you incorporate
Make it as part of the paper book anyways.
Yes, we'll serve.
Gratefully.
I'm for the appellant, my lord.
Yes, sir.
Lordship, kindly come to the order. Order improvement. The memo of appeal. Order dated.
Any private respondents are there?
Lordship.
Service.
Lordship.
Anybody is appearing?
Affidavit of service has been served.
I'm for the state pilot.
Only state is appearing. Copy has been served, my lord, kindly see.
Acha, let us go through the order.
My lord. Lordship, I have not challenged the charge sheet, and learned trial court failed to appreciate that under the changed circumstances, I filed the present writ application. Now, what happened in this matter, Lordship? Rightly, wrongly, one FIR has been registered against the petitioner. Investigation was completed, charge sheet was submitted. Petitioner obtained certified copy of the charge sheet. It appears that one Shankar Ganguly, father of the victim lady, his name has been stated as a charge sheet witness, and he gave statement. He gave statement in the year 2024, whereas the father of the victim lady died in the year 2020. Petitioner narrated the entire incident.
Shankar Ganguly was the
Father of the victim lady. He gave statement under 161.
What was the charge against you?
Charge under section 64 and others, Lordship. Under BNS.
The lady is a major.
Lady is a major, divorced with one child.
Then how are you related with it? You are not.
After her divorce and after my divorce, we married. As per our submission, we married. Subsequently, we got separated. We married in the year 2003. We separated in
You
the year,
married in the year 2003. Whom? The girl.
the lady.
The lady who is
Divorce.
the respondent number.
Respondent number, my lord. Respondent number 7, lordship.
7 is the daughter of Shogato Bose. No?
No, Shankar Ganguly. And name cannot be here, lordship. Lordship, kindly see respondent.
You married the victim lady.
Lordship.
That is respondent number 7.
Respondent number 7. Respondent 6 is the IO. Lordship.
So you you are Kaushik.
Kaushik.
So Kaushik married the respondent number 7.
Respondent number 7.
When?
Lordship. In the year 2003.
2000. Very good. Then what happened?
Separated in
Divorce-
2014.
Divorce given.
No, divorce was not given. She left me
She
out
left.
of her own volition.
She left along with her child.
Along with her child.
That is
During
the
previous child, she got a previous child, and out of the wedlock, with the petitioner, another girl was born.
Very
She
good.
left with all.
in 2014.
14.
Very good. Then what happened?
In 2024, this FIR. Alleging
After 10 years.
after 10 years, alleging marital
Who filed the FIR? Who lodged the complaint?
victim girl, respondent number
7.
7.
Respondent number 7 submitted a complaint against you.
Lordship.
When?
2024.
Very good. This was
Lordship.
investigated upon and charge sheet was filed.
Charge sheet was filed.
So
In the
this lady is the daughter of Shankar.
Shankar Ganguly.
Achha. So in the charge sheet, what happened? Shankar Ganguly's name was not properly incorporated.
No, lordship. Shankar Ganguly's name was properly incorporated. Shankar Ganguly gave statement under 161 CRPC as a charge sheet named witness in the year 2024. Whereas Shankar Ganguly died in the year 2020.
But the name is Shondeep, not Shankar.
No,
It was a typographical error which read
Lordship.
Shankar. It should have read as Shondeep.
Lordship.
So
It
Shankar
is
has died prior to 2024 becomes irrelevant if the actual witness name is Shondeep.
my lord. Lordship, how can a dead person give statement?
Shondeep is not dead. Shankar is dead.
Lordship,
So they are
the
saying-
way I am saying, Lordship, it can be say in that way, but the way Shankar Ganguly has been incorporated in place of Sandeep Ganguly has been incorporated as a witness in place of
Shankar Ganguly.
Shankar Ganguly is not at all permissible under BNS.
So then you got the relief. ACJM granted the leave to make necessary
Lordship,
prayers.
I am showing Lordship kindly come to her prayers after the order
What
passed
was
in
the
the
name in the charge sheet? Shankar.
Shankar.
This
Died.
charge sheet was filed when?
First charge sheet, page 60. Lordship, kindly come page 59.
Give us the date now.
Date.
First
2025.
20th February 2025.
Lordship, kindly come page.
After the death of Shankar.
After the date now, already he is dead.
That is
It's a ghost statement.
2024 he died, Shankar.
Shankar died in 2020. His
2020
statement has been taken in 2024. How can it be? How can a ghost give
What
evidence?
prayer was allowed? You pointed
I am coming, Lordship. Lordship, kindly come page 61.
page
61 of the CAN application.
Can 1.
CAN for appropriate order, my lord.
Can 1.
CAN 1, Lordship. There is only one CAN. Page 61.
এ পড়া যাবে।
Statement of Shankar Ganguly. আমার নাম শঙ্কর গাঙ্গুলি, আমার মেয়ের, such and such, Lordship. Now, Lordship, kindly come page 62. Kindly see page 61, recorded by me, read over, explained on 24/10/2024. Page 61, my lord, at the bottom. Recorded by me, read over, admitted by the IO on 24/10/2024. This statement is
What is the name of your father-in-law?
my father-in-law.
Shankar's father?
Shankar.
Shankar's, oh no, your Kaushik's father.
শঙ্কর গাঙ্গুলি
কৌশিক ফাদার, কৌশিক
শঙ্কর
না 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 না,
Father-in-law.
মেয়েটার তো বাবা শঙ্কর গাঙ্গুলি।
Correct. He's right. My lord, he's right.
Girl's father died in 2020.
So what is the name of the girl's father? Shankar or Shandip?
Shankar, who died in 2024,
2020.
2020, and
The statement is of
statement is recorded in 2024. How it can be? Now, Lordship, kindly come page 62.
Page 61, is it signed by him?
Signed by IO Sagota Bose.
No, is it signed by Shankar? Anywhere?
At the top, I think, Lordship, witness, kindly see at the top, statement of Shankar Ganguly. Behind that, witness, it is there. Now, Lordship, kindly come page 62. A ghost has come down and recorded his statement under 161. Now, Lordship, kindly come page 62.
আমার নাম শঙ্কর গাঙ্গুলি।
শঙ্কর
উপরে তো লেখা আছে শঙ্কর গাঙ্গুলি, স্টেটমেন্ট অফ শঙ্কর গাঙ্গুলি।
শঙ্কর গাঙ্গুলি বাবার নাম হচ্ছে চিত্তরঞ্জন গাঙ্গুলি।
Father of the victim girl is Shankar Ganguly.
Then who is Shandip?
I am coming, Lordship. I am very interesting case. Now, page 62 is the death registration certificate issued by Kolkata Municipal Corporation. Lordship, kindly see. Shankar Ganguly, registration year 2020. Already died in 2020. I narrated the incident
Very
with the.
very good. You must have told this to the magistrate. Trial was continuing, na?
Lordship, this order, I had no idea that this thing has happened.
Come to the order impute. You earlier approached the court in 2025.
Lordship, kindly allow me. I shall try to satisfy.
Yes,
Thereafter,
satisfy, yes.
Lordship, I narrated the entire incident to the higher authority. Higher authority did not do anything. I filed earlier writ petition. At the time of disposal of the writ petition, it was submitted. Page 65. Last para. That after filing the writ petition, IO has realized
After
that
where
such.
you are reading, where you are
Lordship, page 65.
Page 65 is an instruction to the government.
Lordship, it was handed over to me at the time of hearing.
Yes.
Where from it appears, Lordship, kindly come. After making investigation, IO of the said case, LSI Srimati Sagota Bose submitted charge sheet before the learned court of ACJM Alipur on such and such, by Netaji Nagar such and such, dated such and such, and upon realizing some typographical error. So this is typographical error. The entire statement you are recorded and annexed with charge sheet is a typographical error of a dead person. Error in putting the name of Shankar Ganguly, the father of de facto complainant, charge sheet witness, in the said charge sheet in place of actual CW to Shandip Ganguly. Such and such, IO of this case sent a prayer before the learned SCJM Alipur for necessary order to make correction in the above mentioned original charge sheet against the actual name of CSW to Shandip Ganguly, such and such, Lordship. And the prayer was allowed by the learned court on the strength, learned court keeping the same charge sheet as earlier, that is Netaji Nagar such and such, by putting the actual CW to Shandip Ganguly, such and such, in place of wrong CW Shankar Ganguly. So on this instruction, automatically writ petition was disposed of by recording that submission. I had no idea what has happened. I applied for the certified copy. Now I came to learn what. Lordship, kindly come. Page 69.
No. When the writ petition order was passed on 21st April,
Lordship,
charge sheet was filed on 4th of April.
Lordship.
Then why didn't you point out this fact?
I am coming, Lordship. Lordship, kindly come page 69.
69.
After the order passed, earlier order in the writ petition, again I applied for certified copy to verify what has happened. This is the application by the
who is actually the father of the de facto complaint? Shandip or Shankar?
Shandip.
Shankar is the father of de facto complainant who died in the year 2020.
That we know. That
And Shankar is the brother.
Shandip.
Shandip is the brother, Shankar is the father. Shankar is the father, Shandip is the brother.
Instead of the name of the Shankar, my lord, it was wrongly mentioned Shandip. Shandip. Instead of Shandip, it was written Shankar.
Now, Lordship, kindly come page 69.
How it is given? Father's name, Shankar's father's name is given. Shandip's father's name is not there. Page 60. Page 61.
Even 69, Shandip's father's name is Shambhunath.
Shambhunath.
The different person altogether.
Maybe it is the IO who has somehow gathered this. Maybe brother of, I don't know. Lordship, kindly come page 69. What the application used by IO before the jurisdictional court? Kindly see. Page 69. In the court of learned additional judicial magistrate, Lordship, kindly come page 1, 2, 3. I came to notice that some clerical error took place in the above mentioned original charge sheet. The name of CDW2 has been written as Shankar Ganguly, such and such, when the actual name of CW2 is Shandip Ganguly, such and such. Hence, it is prayed before your honor that necessary order may kindly be passed for correction the above mentioned original charge sheet against actual name. So, typographical error, maybe Shankar, maybe Shandip, Shandip, maybe Shankar, Ganguly become, well, but Lordship, kindly enter a statement. Accordingly, order was passed. Page 71. To last order, Lordship, to make necessary typographical error. Is it typographical error? I see very cunningly made that application, got to correct the typographical error on the page 71, Lordship. Last order. 15/3/2025. Last order, Lordship. I have made a prayer to. Prayer is allowed. To only make typographical error to be corrected. Under the shield of that, what IO has done, he has not only corrected the name in the charge sheet with regard to the name, but also inserted.
New charge sheet is at page 72.
Page 72 is the revised charge sheet. After getting the previous order I have shown to your lordship, after this, she files a revised charge sheet, recording the statement and bringing a brand new witness in the charge sheet, which is not at all permissible, I will show lordship. Now, lordship, kindly come page 74.
Sir, go and what will the read code do? Read code will set aside the investigation.
No.
Set aside.
I am coming what prayer.
What you are coming? Trial judge has said.
My prayer is this.
Let us understand what is the order. Trial judge has said that on the basis of that error, read court was approached. Read court said that do whatever corrections you want before the learned trial.
Jurisdictional court.
Now, as regards the these doubtful things which have been done, which you are being arguing now, how can a read court again enter into that issue when it has been disposed of giving you liberty to take steps before the session court?
Lordship.
Now, what is?
I have understood.
Now, charge sheet has been filed. Now you want to, you are the husband, now you are the accused.
I am the accused.
So what is your intention? To prove the investigation to be false. তাই না? That this is a, see, this could not have been a mere typographical error. This is a hoax. The entire story has been
Fabricating false evidence.
for that. What we will help you, tell us. There is already a
I'm
direction. Go and take steps before the, now whatever step if the magistrate has taken, this issue has to be agitated in an appropriate application for quashing the proceeding.
Lordship, I'm getting.
Bow down to you.
In 226,
I'm
we
grateful, ma'am.
cannot exercise the revisional code power of 482. This is a fit case in which you should approach the correct court. Then now the trial has commenced, maybe, I don't know how many
And
witnesses.
trial has not been commenced and charge.
Trial has not commenced. Say that the entire investigation is a host. The very substratum is wrong. On the father's, on a dead man's evidence, you are being sought to be implicated. তাই না?
Problem is this, Lordship. I cannot file 482 because jurisdictional court rightly passed the order. There was typographical mistake.
No, typographical error, he cannot, if we are to
What
accept
he
your
has done,
argument.
Lordship, under that order, he has replaced the entire witness. Lordship,
No, Mr. Kindly come to page 61.
61 টা ওটা হোক, হ্যাঁ 61. Lordship, kindly see. It cannot be done.
This evidence has been discarded. The Shankar Ganguly evidence has been discarded from the file. Sandeep has been brought in.
This replacement I have challenged. This cannot be done.
This replacement you cannot challenge before us, sir. How can you challenge before us?
I have prayed restoration of charge sheet in its original position.
That
As because I cannot pray
Opportunity
before
to
the
file
jurisdictional
narrative
court.
before the
I cannot
jurisdictional
because
court.
there is no such provision.
against the order of the magistrate saying it is a typographical error, against that order itself you could have gone and filed appropriate application.
I had no idea because I was not given any opportunity.
Even my lord, his remedy is available before the jurisdictional court. He can file Naraji petition at any point of time if he is dissatisfied with the charge sheet. So, my lord, he has unnecessarily, my lord, invoked the jurisdiction of the writ court, and that is reflected in the order of the learned or honorable single judge.
Lordship, the way new witness has been inserted is not permitted. Under the BNSS, only by way of supplementary charge sheet if the investigation has not been completed, or by way of further investigation. That too with the leave of the court, you cannot insert a new witness. How the IO has inserted this page 74.
That is after the magistrate's order. Magistrate said.
Magistrate, kindly see the conduct. Magistrate directed for correction of typographical error with regard to the name only. Under that seal, what IO has done, he has took out that, perhaps, Lordship, kindly see the application used by the IO. There is no whisper that I have recorded a
Apply for quashing. Go and file a quashing application.
Of the
This
charge
charge sheet itself is bad.
Lordship, I can, but with there is two charge sheet now. Original charge sheet, revised charge sheet. And he has, IO has take out that.
What was the allegation
there.
against? What
So
was-
my case, my defense, I am not getting. On what ground I shall?
You have now come up with a plea that a fresh.
Had there
charge
be
sheet
a
has
dead
been
man's statement there, I definitely I could have filed question
Why?
application.
We should not advise you, sir. If there is a fresh charge sheet, very good. That fresh charge sheet makes the case worse.
Revised charge sheet also, Lordship, there is no such provision.
So
Lordship,
then the proceeding has to go. How can we help you? Tell us.
I have prayed two prayers, Lordship. First, okay, very well, I am not on that. Restoration of charge sheet in its original position. My first prayer is this. There is also a second prayer. Appropriate criminal and departmental proceeding against the IO. Why I am saying this? What about that order? Lordship, kindly see under 228, fabricating of false evidence. What is fabricating of false evidence? Whoever causes any circumstances to exist.
That is an issue to be decided in the trial.
Lordship, the conduct of the IO. Now, simply because he is a police officer,
you have accepted that order. You have gone to the magistrate. After the High Court given that you take necessary steps for correction, come to the order.
No, before that, before High Court order, she got the copy of the writ petition, went to the jurisdictional court and got the order. Now, at the time of hearing, he says, true state, that, look, I have got an order. What order? Typographical error with regard to name only. There was no such order that you replace the entire witness. You replace a dead person with a living person. That replacement cannot be done, Lordship, under the BNSS. Lordship, kindly allow me to read
What is the stage of the trial? What is the stage of the trial? It has
trial has not been started. Charge has not been framed. Only issue has been started.
The charge has not been framed. You take this point before that.
At the time of charge, I cannot raise this question that there has been replacement. This charge cannot be. That is separate issue. I can challenge whether I accept 64 or not. Whether I am ready to go for trial or not. That is only. Charge will be typed and read over it me whether you accept or not. I cannot raise these things at the time of charge. This is also my.
Who told you? As regards framing of charge sheet is also an interlocutory order in this sense.
Process
if you have to you are the accused. You are the accused.
And I am.
What debars you from raising this point? We don't understand. I don't understand. Charge has not been framed against you. So it will be tendered, you will be stopped from pointing out these errors to the court. You are anticipating that.
Under what scope, Lordship? I am only challenging the replacement.
ওর কথা হচ্ছে কি একটা চার্জশিট ফ্রিভোলাস ছিল ফ্রিভোলাসটাকে কারেক্ট করতে অন্য লোকটা এই ইস্যুগুলো তো ট্রায়াল কোর্টে করবে
Departmental proceedings.
এরপর আমি ওটাকে চ্যালেঞ্জ করতে পারছি না কারণ ওটাকে টাইপোগ্রাফিক্যাল এরর বলছে সেটাই তো পয়েন্ট in the guise of a typographical reopening investigation. Your argument is in the guise of a typographical error. They are making a new investigation by incorporating another person in the name of
incorporation of a fresh witness.
That cannot be. Lordship, kindly allow me to read once.
We are with you, sir. We are not saying it cannot be done. We are saying that it is a wrong. You have to agitate that before the trial court. Take this point.
And what, Lordship, I have two prayers. Lordship, kindly. I read in the nature of mandamus commanding the respondent number 6, that is DCP, to forthwith restore the original charge sheet. Very well, I shall go by your Lordship. Now, Lordship, kindly come page 54, prayer B. I have twofold prayers. Lord.
Page 54.
Page 54, prayer B. Present writ petition, which is before your Lordship. Prayer B. I read in the nature of mandamus commanding the respondent number 6 to show cause as to why appropriate direction should not be passed by this honorable court, thereby and thereunder directing respondent number 3 to initiate appropriate criminal as well as departmental proceeding against respondent number 6 under the changed circumstances as stated above. Page 54. Wherefrom I got that statement. I could have understood with regard to name very well. An entire statement. A person who is giving statement 24 died in 2020. Should these officers go on? They will harass every citizen. What about my prayer B? Let there be some lesson to this IO. No, you cannot do this.
before return of a finding that the second charge sheet is bad. It is yet to be decided. Your argument
Lordship,
will be considered by the magistrate.
Lordship, I am
Departmental proceeding.
I am inviting this honorable court to take judicial notice of this thing. This type of investigation, dead replacement is also bad.
This you two should have taken in the first writ petition. Where is your first writ petition?
At the time of first writ petition, I had no idea. After
Let us see the first writ petition.
Lordship, first writ petition, page 54 is the order. No, earlier. Page 94, Lordship. I am very sorry. Page 94. I have annexed.
It is only the order.
No, page 94. Challenged only, a dead person came down and deposed. Made statement under 161. In that writ petition. Order passed.
And you said it was a typographical error.
I am not saying. IO is saying only typographical error.
What were you doing, sir? Your argument before us, you should have made at the first instance.
I had in the
Page
first
61 was there.
Lordship, in the first writ petition, I told.
You said
a
that dead person with evidence cannot be taken. A person died in 2020. How can he come and depose in 2020?
This is my question,
So
Lordship.
that point was open to you at the time of first writ petition.
I took that plea.
So you did not challenge that order.
I
read court order saying rectification of correction of error. That was not challenged.
Lordship, everything I came to learn at the time of hearing of the first writ petition that she has already gone to the jurisdictional court and got such order. Relying upon that,
which court?
Before the learned decision. At the time of hearing of the first writ petition, I came to learn that IO has already gone.
When was that order passed? Magistrate order?
Magistrate order, Lordship.
15th of March 2025, Lord.
15th March, and
March
first writ petition was first writ petition.
Lord, first writ petition was made, Lord.
Page 67, Lordship.
25th March 2025.
First writ petition.
27th March 2025, Lord. 27th, page 98.
27th March.
27th March.
So before he filed the second writ, that correction had been done.
My lord.
Lordship, this is the conduct.
না সেই জন্য এই অ্যাভিনিউটা তো খোলা রেখে দিয়েছে।
To escape from
no, my lord, order has been
liability of criminal liability, 7-year punishment.
15th March, magistrate passed the order. 15th March, magistrate passed the order, and this writ petition has been filed, my lord,
second
on
writ
27th March 2025. This is the first one.
Yes, so it had already been done.
Already been done. So it was not agitated in the first writ petition.
No, but
your lordship has rightly pointed out.
He says he did not know about it.
But he was very much acquainted since he was conducting the trial on regular. He is appearing before the my lord, jurisdictional court on regular basis.
So what was the charge? What has he done? What is the allegation against?
My lord, may I place before your lordship, my lord, the charge sheet?
No. Just a moment.
No, janto na eta.
Charge sheet.
Very serious allegation against me, my lord. Things should not be taken so lightly by the IO.
Have you served this person?
Swagata Bose, Lordship. She has also received. Kindly see the.
Anybody
Let him come and satisfy the court.
Anybody appeared on her behalf?
No. Before the trial court, nobody appeared, and before your lordship is also nobody. But she has received. IO has received. Let him come.
ফুড অর্ডারে বলছে যে তুমি যা করার তুমি ম্যাজিস্ট্রেটের কাছে। এবার ঘটনাটা এরা শঙ্করের নামটা চেঞ্জ করবে। কি নাম? শঙ্কর আর শক্তি নাকি? শঙ্কর সন্দীপ। তো শঙ্করকে সন্দীপ করলে আপনাকে নাম শঙ্কর একটা সন্দীপকে ঢোকালে তাহলে তো টাইপোগ্রাফিক্যাল কারেকশন হচ্ছে। সন্দীপকে দিয়ে ফ্রেশ এভিডেন্স। You are making a misrepresentation to court as the IO.
He has not done further investigation or supplementary charge. Nothing.
Sir, how do you explain your stand?
I'm good.
Milord, my explanation is, Milord, at the first instance, Milord, when it is detected, Milord, they made the jurisdictional, they made the Milord error. It is no doubt. Fact. And subsequently, Milord, by virtue of her prayer, Milord, IO has rectified all this.
So it's not a rectification. That's exactly what we are thinking. You see, had Shankar been changed to Shandip, that would have been a rectification. Shankar's statement was completely withdrawn. And newly, Shandip's is introduced. That's not a typographical error. That's introduction of new evidence.
My lord, only the name has been changed.
No, he has paid 74. He has given a fresh statement. Careful.
Milord, his remedy is available, Milord, before the trial court, as well as criminal court. Milord, he can file the quashing. Milord, he has unnecessarily invoked the jurisdiction of police in action, Milord, under the REET jurisdiction, and Milord, in order to frustrate the trial, Milord. This is the basic criteria. Error has been made, Milord, admitted. But his remedy, Milord, obviously lies before the Milord 482 jurisdiction.
Page 74, what is the date of that order?
No, there is no such date. When it was recorded, before filing charge sheet, after charge sheet.
Take your seat, Biyama. You file legible copies of the charge sheet. We cannot read it also.
Come with legible. I have, Milord, the original copy, if your lordship. So once, Milord, I can show it to your lordship.
Do you have the case diary you have?
My lord.
Now, this evidence, when did you incorporate? The Shandip's evidence?
It's 74.
The Xerox copy, my lord.
To take this instruction.
My lord.
This page 74. When was it filed?
Filed. I shall come back, my lord, with the instruction when it was filed.
Because Shankar's, it was recorded in 2024. He died in 2020. So that statement could not have come into the case file also. What Shankar has said, that is page 61. He has expired in 2020.
My lord.
So where from did you, is the same investigating officer?
Yes, lordship, sir.
Please ascertain who signed page 61 and who signed page 74 and what are the dates?
My lord.
Page 61 you have seen?
My lord.
that wrong Shankar.
Is there, my lord. 24th of October.
Right, 24th October 24. Person was not alive on that.
My lord.
Now, his contention is when I filed the first writ petition, it was not in his remembrance that another fresh charge sheet will be filed. He was under the opinion that yes, genuinely there has been a problem. Maybe Sandeep's evidence, the investigating officer took Sandeep's evidence 161, but by typographical error, that statement has been recorded in the name of Shankar. But the case is not that. Case is page 61. Shankar statement is there. Now you are taking away Shankar statement, saying it to be a typo, and you are incorporating page 74. Then when did you take the evidence of Sandeep? Page 74 evidence, because after the charge sheet has been filed, typographical rectification it can be done. But the entire tenor of the investigation cannot be changed. That let me take fresh evidence and file a second charge sheet. Then there is a provision, you can make further investigation. If it was further investigation, that we want to know. If you can say that after the court's order, typographical error was removed, fresh investigation was started, এটাই হয়েছে. And during investigation was started, evidence of Sandeep was taken, fresh charge sheet was filed.
My lord.
If you can show us that, very good. But here he will not be able to produce. For that, you have to check up whether the earlier charge sheet statement and this charge sheet statement is the same or not.
My lord.
The investigating officer has to come to a prima facie finding as regards that. You ascertain that and tell us. From the case diary, you get the date of those two.
My lord. I shall take the necessary instruction.
When can you come tell us?
1 week time be given.
So affidavit of service, as file be kept on record. That is your.
Not sure. 11th August probably.
For further consideration.
I have to take
on-
instruction. Lordship. Matter to appear.
5174.
My lord. I'm taking instruction.
24th.
24th.
July.
28th, sorry.
28th July.
28th July. I'm grateful, man.
Deeply obliged.
Lordship, may I pray another since appeal is pending before your Lordship, May I pray for stay of other
Next, you're saying date is in August.
August?
We will take it upon that.
As it.
Will be a matter.
At the very outset, Milord, I am representing Milord, the government of Odisha, Milord. But Milord, what I am in difficult because the learned additional Solicitor General is leading me in this matter. Additional Solicitor General Odisha. Milord, he has prayed Milord that Milord can take it up at 2 p.m. because Milord, we have already got the report. Milord, those gentlemen have already been released and they are no more. But Milord, I intend that the learned additional Solicitor General should place it.
Anything remains in the matter.
Lordship,
Chakraborty is there.
I am in Vichy mode, subject to the leave of this honorable court. I may be allowed, my lord.
Yes.
My lord, this is the detention was illegal. Lordship, I am seeking leave, my lord, to join through Vichy mode.
What, Mr. Chakraborty, persons have been released. What is your problem? Why you are...
No, my lord, the detention is illegal.
So you want...
My lord, this is one aspect. The other aspect, when I was released, my lord, 100 persons are there. And the Odisha, my lord, taking this policy and doing all this mischief in the same fashion. Persons are not so, my lord, financially equipped to come to this honorable court. My lord, regular basis. Let a decision be taken, my lord, whether this kind of detention is legal or illegal. My lord, that is why, my lord.
Restrict yourself to the petition.
Lordship.
You are appearing for the person, restrict yourself to the person. We are not... How many persons? You come from...
True, my lord, but that...
Where are you?
Well, that is Calcutta. Today I am on Wednesday, my lord, the other matter is on Wednesday, my lord.
Humble submission, my lord. I am appearing for the police authorities in this matters, my lord. Led by Mr. Bandopadhyay, my lord. My lord, in this matter, my lord, there are two other matters which has been fixed by my lord on 16th at 2 p.m. my lord. Those matters are pursuant to the Delhi. There are few matters in Delhi, my lord. Let this matter be also kept there, my lord. Only, my lord, I am not placing any documents. Only for the facts and circumstances, my lord, we have the knowledge as of now that there are around 548 people in Odisha having the same fate. There are other states which is having the similar problem. So, my lord, let the matter be kept.
You are not the petitioner.
I am not the petitioner, my lord.
So wait,
but my lord,
we know your stand. You need not elaborate on that.
My lord, we'll only keep it together, my lord, so that
yourself for the respondents who are
Lord, but as the state authorities, my lord, it is also our responsibilities to see that the people of our state are not harassed and heckled.
We are concerned with this case.
My lord, I'm just saying, I'm not expanding the thing.
Yes, you are saying now, no?
My lord, let this be kept at 2 p.m. on 16th, my lord. With other two matters, let all.
No, this is also my lord, the prayer. Let it be on 16th. Today I am in difficulty, my lord. Otherwise, I used to appear physically, my lord.
The only persons who are not in difficulty. We are the only persons who are not in difficulty. It is the advocate concerned who is in difficulty. Such a serious matter at a time. You people are not bothered. You people are not bothered. You are not there to assist the court. Very unfortunate. Unfortunate.
Is it possible, my lord, to take up this matter on Wednesday?
Exactly what we have to do. It is your prayer. How can we can throw you? I am appearing in VC. And we cannot hear you properly also. Then if you have left the court, you should have kept somebody who could have argued on your favor.
My lord, my learned senior is in Delhi, my lord, for some matter.
We are very happy to learn.
My lord, that's why.
We are happy to learn that he's in Delhi.
My lord, on behalf of the state, may we only pray that if this matter is kept on 16th along with the two other.
Yes, it will be on Wednesday, Mr.
Another thing, last day, Bandopadhyay had appeared, my lord. But somehow his appearance has not been recorded.
Come and tell us next. Yes.
কটার সময় অর্ডার করতে পারো না
আজকে appearance দিতে
Wednesday your lordship is fixing any time
On the time when that will appear, ওটা কখন It will be there on Wednesday at 12 noon.
12 noon.
12 noon.
We have another bench on that date, so we kept it on 12.
Right.
Come back, let us see what is it.
Deeply obliged.
মনে তো হচ্ছে না
appear for the passed by the regulatory commission, which has been affirmed by the learned single judge, but they do not wish to proceed with the appeal. This is the written instruction.
Appear for the respondent number 4. It has been paid. It has been paid.
আরেকটা কপি দিয়ে দিন। The clinical establishment was the appellant.
Madam.
Lordship. I beg to represent the appellant Lordship, led by learned Advocate General in this matter, Lordship. Yes, sure. There.
Yes.
My lord, the impugned judgment, my lord, in my humble understanding, my lord, carries two observations. One is, my lord, reading down of Rule 4 of the, my lord, special marriage rules. And, my lord, Honorable Single Judge, secondly, has, my lord, drawn a parallel between Rule 4 and Rule 6. And therefore comes to the conclusion that on the issue of appointment and compassionate appointment, Rule 4, Sub-Rule A, read with Rule 6, will be applicable. Thirdly, my lord, Honorable Single Judge, my lord, has been pleased to hold that yes, she is 52 plus. It can be read, it can be in a compassionate appointment, can be ignored. And so far as the educational qualification part is concerned, the Honorable Single Judge says that since she is from some open university certificate, it can be read as equivalent to 10+2. My lord, may I respectfully invite your lordship, my lord? May I, my lord, respectfully hand over, my lord, the books, my lord. It's two books. Before, my lord, respectfully inviting your lordship, my lord, to the book, may I, my lord, respectfully invite your lordship, my lord, to internal page 4 of the, my lord, impugned judgment, lordship. Internal page 4, my lord, may I read out a careful perusal. The sentence starts with, of 2010 rule shows that Rule 4 has been captioned to be qualifications and other conditions for appointment as non-official marriage officer. In such context, the applicant is required to have certain qualifications as stipulated in subclause A onwards of the same. The proviso to subclause A of subrule 1 of Rule 4 has been given under the category, he shall be a citizen of India. In the proviso, it has been stipulated that a dependent of an appointee who has died in harness may be appointed by the government to the post subject to the procedure as given therein. The said procedures from subrule 1 to 6, however, are not a part of the subsequent subclauses B onwards. The stipulations 1 to 6 under the proviso fall under the subcategory A of Rule 4.1 and are disjunctive from subclauses B onwards of Rule 4.1. As such, the appointment of any dependent of an ex officio marriage officer to the post is not necessarily circumscribed, but the other restrictions given in subclause B onwards, which are in terms applicable only to appointments as non-official marriage officers at the inception. Reading down of Rule 4. Kindly seize, my lord.
Not reading down, court says that those are disjunctive.
As because those candidates who are willing to be appointed as a registrar at the inception, the new recruits, the clauses B onwards of Rule 4 are meant for the newly recruits, not for those who are praying for appointment and compassionate route. This is what has been said. Fresh.
No, which is the clause for appointment on compassion? Rule 4.1a.
Lordship, he shall be a citizen of India.
Which page are you reading?
My lord, 2.36. May I just point? This is very difficult.
So what tell us?
Of special of this book. Special marriage rules.
His father was a non-official.
Her father was a non-official marriage officer. Those who get the license under the Special Marriage Act, they are called non-official marriage officer.
Under the Special Marriage.
Under the Special Marriage Act. 2.36, my lord. May I find out, Lordship?
I have
Already. Miller, kindly sees Miller, may I respectfully invite your Lordship to Rule 4.
Just one. Yes.
The nomenclature, Miller, is qualifications and other conditions for appointment as non-official marriage officers. The applicant shall have the following qualification. He shall be a citizen of India, provided that if any ex officio marriage officer dies or becomes permanently incapacitated due to accident or serious illness. So in this case, a death case. While performing the duty of ex officio marriage register, the state government may appoint any dependent of such ex officio marriage officer to the post, subject to the following procedure. If any ex officio marriage officer dies or becomes permanently incapable due to serious illness, so and so, so and so, so and so, his son, daughter, or spouse who lives within the, so in this case, she is the spouse of the deceased nomo, Lordship, who lives within the jurisdiction to which the ex officio marriage officer has been performing duties and who has requisite qualifications may be eligible for being considered. Requisite qualifications. Requisite qualifications may be eligible for being considered for appointment as ex officio within that area. 2. The intended candidate shall, within 6 months from the date of death or permanently incapacity, as the case may be, apply to the Registrar General of Marriages, West Bengal. 3. The applicant shall specify in the application his name, father's name, date of birth, address, educational qualification, other qualification, relationships with the ex officio marriage officer who died or become so and so, if any, along with the supporting documents. 4. In case the ex officio marriage officer becomes permanently incapacitated, the applicant shall submit original medical certificate to that as so and so. 5. On receipt of the application, the Registrar General of Marriages shall consider suitability or otherwise of the applicant to the post of ex officio marriage officer and shall forward the application with his recommendation to the state government in the Judicial Department. On receipt of the recommendation of the Registrar General of Marriages, West Bengal, the state government may appoint the applicant to the post ex officio so and so. As per the Miller observation of the Honorable Single Bench, up to this only is applicable to an applicant who is paying for compulsion appointment. The rest, kindly sees, he shall be a permanent resident of the local area for which he is applying for. He shall not be less than 25 years and more than 40 years as on the closing date of the receipt of the applications, provided that the upper age limit shall be relaxable by 5 years for women and physically handicapped candidates, and for candidates belonging to the scheduled caste and scheduled tribes and the other backward classes. Provided further, the state government may, for any reasons to be recorded in writing, relax the minimum age or upper age limit of any candidate. He shall have a pass certificate in higher secondary 10+2 examination from a recognized board, council, madrasa. He shall have workable knowledge of computer. He shall be well conversed in the language of the area for which he is applying for. He shall not hold a full-time employment in central government or state government or so and so.
Court says clause 4A 1 to 6 are not applicable in respect of 4B. 4B onward.
1 to, yes. B onwards, not applicable to a candidate who is praying for compassionate appointment. This is what the observation is. It is applicable to whom? Those who are praying for, those who are fresh recruits.
That's why he says it's disjunctive.
Disjunctive. Now, second observation. Kindly seize, my lord. If I may again, my lord, try with your lordships, my lord, to come to internal page 4 of the judgment under my lord, judicial appeal. Lordship. Kindly say, what does it say last paragraph? Rule 6. Now it deals with Rule 6. Rule 6 of the Rule 2010 rules, on the other hand, contemplates appointment of marriage officers from the panel prepared by district committee. Under sub-rule 1, therefore, thereof, the state government shall, in accordance with the provision section 3, appoint non-official marriage officers from the panel prepared by the district committee on the procedure followed therein. So, my lord, as per section, my lord, these nomos, they are appointed in accordance to section 3 of the Special Marriage Act. The proviso thereto has a similar clause which stipulates that when a non-official marriage officer dies or becomes permanently incapacitated due to accident or serious illness, while performing the duties of non-official magistrate. The state government may appoint any dependent of such non-official magistrate to the post, subject to certain procedures as mentioned therein. The said procedures, which are akin to procedures given under the rule, provides Rule 41A, also do not envisage any of the riders as found in subclauses B onwards of Rule 41. Miller, may I respectfully invite your lordship to Miller 6. 6, Miller, kindly see the nomenclature. It is the appointment of marriage officers from panel prepared by district committee. State government shall, in accordance with the provision section 3, appoint non-official marriage officers from the panel prepared by the district committee on verification of qualifications of the candidates and on receipt of an affidavit relating to fulfillment of other conditions for appointment as non-official marriage officer, provided that if any non-official marriage officer dies or becomes permanently incapacitated due to accident or serious illness while performing the duties of non-official marriage register, the state government may appoint any dependent of such non-official the post subject to 1 to 6 minute. I do assure me, Lord, these are same as that of Rule 4, Lordship. So my respectful submission, if my Lord, Rule 4 sub-rule A 1 to 6 read with Rule 6 1 to 6 are only applicable to the applicants who pray for a compulsion appointment. May I pose this question to myself? Does it mean that those who want to be appointed as a NOMO, they shall not have to satisfy the qualifications as contemplated under B onwards of Rule 4? He shall not have to be a permanent resident. Kindly see B onwards. He shall not have to be a permanent resident. He shall not have to be less than 25 years or more than 40. Provisos are there. He shall not have to have passed a certificate of HS.
Now, you have rejected her claim by which order?
Lordship. Impugned order is, I should be very candid and honest. At page 50, Miller kindly takes up page 50 of the stay application, 50. It's cryptic. I should be very candid. Kindly see page 50. This is the rejection order.
In respect of spouse, two things are standing in the way. First is the
A.
certificate.
Yes.
Second is the age.
Lordship.
Then Mr. Galib, show us what was the learned single judge's reasoning to come at that finding?
With regard to age and qualification.
No, qualification you leave. Qualification, it has been, there is another, what he has detailed.
No, qualification, my lord, I should be very, my lord, honest in presenting this submission, respectful submission, that in the appeal stage, my lord, we have cross-checked her certificate from the institute wherefrom she has obtained it. That institute itself says that she did never appear from our school. This certificate was never awarded by us. Summon substance is, it's a fake certificate. This is one of the grounds of the state.
But there was a reply by the governmental authorities that it is equivalent.
No, that with regard to some other case, they drew an analogy.
Oh, that is not in.
And not in this case. Honorable Singh drew an analogy that in other cases you treated this kind of qualification as equivalent. Why are you not treating? But here the question is, we are going to the root of the matter. The qualification certificate which she is relying upon is a fake certificate because the government of West Bengal cross-checked it from the Delhi government, from that school, Bihar school. They say we have annexed those documents, Lordship. The communication by the government. May I show that, Lordship?
Oh, please tell us this waiver of age criteria.
My lordship.
Pointer or keep similar fake certificate.
My lord of the imperial judgment, lordship. The sentence will start with as such. Lordship's got this.
Yes.
As such, the petitioner has at least provided a semblance of a document to indicate that she had the necessary eligibility for the purpose of becoming an appointee in the normal category. Although the age criteria of the petitioner was not met on an equivalent footing with an original applicant, the same could very well be relaxed in case of compulsion appointment, particularly in view of no such strict eligibility criteria being appended to Rule 6.1 of the 2010 rules. So, Honorable Single Judge is relying upon Rule 6 of 2010 rules to give the benefit to the petitioner, since Rule 6 does not contemplate any age criterion that can very well be relaxed. So, Rule 4 has been read down and Rule 6 has been relied upon.
The judge says that Rule 6 proviso will also not be applicable.
Yes, all the Rule 6
So 1 to 6.
will be applicable. Because Rule 6, 1 to 6 are in pari materia with Rule 4, 1 to 6.
Now, in Rule 6, where is the age criteria?
There is no, that's why Honorable Single Judge said in Rule 6, there is no age criteria. Point number 1, since it's a compassion appointment, it can very well be relaxed. Point number 2, even Rule 6 does not contemplate any such. Because Honorable Singular relied upon Rule 6 to give benefit.
What is your argument to that?
Argument to that is, my lord.
So Rule 6 also applies to normal.
No, my respectful submission with regard to this point is, my lord, kindly see what is the difference between Rule 6 and Rule 4. Rule 4 is, my lord, prescribing, my lord, the qualifications, my lord, which the norma will have to have. Rule 6 is not prescribing qualification. The only rule which prescribes or contemplates or envisages, my lord, qualifications, my lord, which, my lord, the applicants or any candidates will have to possess are only and only contemplated in Rule 4. Secondly, this 1 to 6, which your lordships are also seeing in Rule 4 as well as Rule 6, these are kindly at the procedures.
For?
Procedures, my lord, kindly sees for those
procedures.
Candidates
1 to 6.
1 to 6 of Rule 4.
1 to 6 of Rule 4.
As well as 6.
1 to 6 of Rule 4 is not the procedure.
Kindly sees, my lord.
I've seen.
Following procedures. It is written.
It is criteria. It lays down certain criteria. 1 to 6 lays down certain criteria. It's like a parameter. See? And
kindly sees, lordship kindly sees.
If you see, Mr. Galib, 1 to 6 is not part of 1. It's not part of 4.1a. It's part of 4.1a proviso.
Yes.
So that is why, or that is how it may be construed as being disjunctive. May be construed, subject to hearing.
My lord, proviso, my lord, has,
you see, A is he shall be a citizen of India. That's
Lord.
where it stops. A stops there.
Lordship.
Then is the proviso. And 1 to 6 are in aid of the proviso.
Kindly, my lord, lordship, my lord, provided that, if I may read the proviso part.
Yes.
provided that if any ex officio marriage officer dies or becomes permanent income source and so and so, the state government may appoint any dependent of such ex officio marriage officer to the post, subject to the following procedures.
Procedure is its criteria.
Lordship, let us take it as criteria.
If it is a criteria,
So
then
these things will have to be fulfilled.
if it is a criteria, if we are ad idem on that, then the next question is criteria to what? Can it be said it's a criteria to the persons reserved in the proviso? See the proviso.
It is meant for the compassionate applicants.
Correct. So then 1 to 6 becomes an exclusive procedure, criteria, whatever for those persons.
In that even, Miller, there, what about this, since we are to read that he or she should have the educational qualification, even illiterate also can be appointed as a
then 6. That's how 6 comes in.
No, 6 also does not take care of all this.
Yes.
6 also, Miller,
6-1. Again, you see, 6-1 to 6 is part of the proviso. And it says requisite qualification.
No, that is where I am on, Lord. Kindly see, Lord, 6 also says, kindly see subsection 1, the first paragraph before proviso. The state government shall, in accordance with the provision section 3, appoint non-official marriage officer from the panel prepared by the district committee on verification of qualification. So, my lord, the qualifications are only and only contemplated in Rule 4, nowhere else. And, my lord, Section 6 contemplates appointment of marriage officers from the district committee. That is, my lord, altogether a different thing.
But why are we going into that, Mr. Galip? Let us say we are with you. Or let us say we are not with you. Even then you're saying this lady has produced a forged mark sheet.
That is, well, that is my next next level of argument. May I place that, my lord? May I place that?
Adding to what my brother has said,
Lordship.
what according to you, Mr. Galip, is the reason for non-incorporation of an age criteria within the criteria 241A provides? Why didn't the legislature incorporate that? Because in clause 3, applicant shall specify father's name, date of birth, address, education, other than that. But you are consciously not including that qualification. If you are over 40, your part, she goes. Like, what is the reason behind?
In my humble understanding, my lord, and as for submission, that the entire Rule 4 is applicable to the candidates who come for or with the prayer for compassionate appointment. That is why entire Rule 4 has taken care of the age.
Then you are making a distinction, Mr. Galip. Suppose if you come to that clause C, 4.1.
Lordship.
The upper limit is 40.
20, yes.
Okay. Suppose the person who dies is 47 and the wife is 42. Then immediately she is disqualified.
Relaxation criteria, that's the proviso has been added to it.
Discretion. That's a discretion. She's immediately disqualified.
Lordship, may I respectfully submit, my lord. Well, compassionate appointment also, my lord, cannot be divorce the rules, my lord.
Compassionate appointment.
Cannot be divorce the rules.
Compassionate appointment, you have laid down certain criteria. In that, you've not mentioned the age criteria.
No, age is there, but relaxation is also there for reasons to be recorded in writing.
That is for original appointment of a manager.
Well, it is nowhere. That is what the Honorable Single Judge has said. But we are on Rule 4 that it is applicable to one and all. And what my learned, my lordship, Honorable Justice MITRA has been pleased to me, Lord, say that what will happen to a person who comes for compassionate appointment crossing 40.
Yes.
In my respectful reply, my lord, I say, my lord, clause C of Rule 4 has taken care of. They have the relaxing power. Upper age limit shall be relaxable by 5 years. Not only that, kindly see second proviso provided further, the state government may, for any reasons to be recorded in writing, relax the minimum age or upper limit of any kind. So second proviso does not give any ceiling. First proviso says up to 5 years for women, but second proviso does not give any ceiling.
No. The ceiling is given in the first proviso.
Yes.
Sorry, in C. In C,
less minimum 25, maximum 40.
Correct.
Then first proviso, upper age limit.
No, Mr. Galib. The first proviso says you can relax. Second proviso says you have to say why you're relaxing. Doesn't No, you're reading too
like
much
it
into
is further.
Yes.
Will have provided further
for reasons to be recorded in writing. That's the second proviso.
Yes, so state has.
If you relax, how much or why? Not how much, why you're relaxing is what the second proviso says. First proviso says you can relax.
Up to 5.
Correct. Second says you must state why you're relaxing. It is not a further.
So lordships means wants to say, Milord, that it can be only maximum is 5.
Correct. That's
and
the understanding.
Any relaxation reasons to be recorded.
That's the second proviso. It can't be that if you relax within 5 years, then you don't have to give any reason.
Milord, kindly sees, Milord, but in my humble understanding, subject, of course, Milord, to be lordship, provided further, the state government may, for any reasons to be recorded in writing,
right,
relax the minimum age or upper age limit. That means, Milord, this minimum age relaxation and upper age limit relaxation is to be read with juxtapose, Milord, the very first sentence, that is original C. Less Milord, minimum age is 25 and upper age is 40. So this proviso is to be read with the first one.
5 years.
No, middle one is 5. But this one is that can be at any point. With regard to minimum and upper. Thereafter can be.
You have annexed text for the compulsion for that educational qualification.
We have, my lord.
That was not before the report.
Subsequent, my lord, it has been collected.
It was placed before the report.
No, it was not. You have not
Mr.
placed it before. No, it was not before the read court, lordship.
It was not. Then Mr. Mitro, you
My lord.
filed a short affidavit on that point. Age qualification is there saying, apart from this age criteria, because that was not before the report. So you give a short affidavit on those two issues, and we come back and hear it out. It is a point of.
Kindly fix up a date, my lord, for hearing this appeal.
Affidavit file করবেন না? You have filed any contempt application?
No. Very poor litigation cost is so high.
No, if he says that the qualification he is raising a doubt, you did not get the opportunity to read that point before the report because those documents were not.
But I will show, my lord, the document that has been annexed with the stay application, the last page, only to mislead the honorable court. Because she submitted the birth certificate from Bihar Board Open School, but they have taken the instruction from other board. My lord, may I come back on tomorrow, or if my lord so pleases to direct me to file an affidavit, I will come back with that.
That is not our. If you say that you need not put any affidavit on that issue, that is a separate thing.
No, my lord, but I will come. I should come back with that.
Clarify করে দাও।
My
Very good. কাজ হচ্ছে।
My lord, can it be 20th?
20
20.
আচ্ছা ওইটা 11th বলেছিলাম না ওটা তাহলে ওর একটু বাড়িয়ে দাও till 18th and
20th August.
from 20th 20
Lordship.
এই নোটটা দেবেন একটু, হ্যাঁ?
লটটা নোট।
If it may please your lordship.
May I seek my lord's liberty to mention, if my lords may allow me that? Am I audible, my lords?
Item 56, she's appearing in item 56. She just has to make one submission to your lordship.
My lords, only a moment. I won't take your time. My lords, I appear in item 56 for the appellants. Now, my learned colleague, Mr. Ashok Banerjee, has made some extensive submissions here. I am adopting his submissions, but I only would wish that at the stage of rejoinder, if there is something to be said, my lords may give me an opportunity at that stage. Only to the extent of rejoinder, nothing more. As of course, my learned colleague has made submissions. I'm not repeating. It would amount to a repetition of the whole thing.
In reply, if you have anything to say, you inform us.
Please, my lords. My lords, I'm extremely grateful for that.
Yes.
May I hand over?
Yes.
Lordship, may kindly.
No.
নোটটা দিয়েছি?
Yes, you tell us you are appearing in which appeal?
Lord, I am appearing MAT 1322 of 23. Possibly lordship took note of MAT 1322 of 23. But I shall be referring the pages from the paper book of
1322. 1322.
Yes, of 23.
Of
23.
Name?
Chandan, surname কি? Chandan Das.
Yes.
There were 635 candidates, some of which they were before the Honorable Supreme Court. And so far as our appeal is concerned, our leave and stay, that was done by order dated 12th of September 23.
September 23. By which court? By Justice Talukdar?
No, it was by the Honorable Justice Showman Shen and the Honorable Justice Siddhartha Roy Choudhury.
12th of September.
Yes, 12th of September.
Yes.
Now, my lord, I continue from.
আমি যেটা আমারটা যেটা
For a change. Change always tastes better.
Yes.
Well, at my
You will say from 873.
Lordship, may kindly take my note and the paper book. That is
You
board's
will-
paper book. What Lord?
paper? That
Yes,
is
yes,
873.
yes, yes, yes.
Yes, tell us.
Yes. Well, at my first point.
What
before you-
paper book you have given?
Sorry, my lord.
নোটটা যেটা দিয়েছে না। You have handed over anything?
I have handed over, but I
Which
just
one?
thought there is a possibility of so many voluminous documents. I have got it ready, another copy. So whatever Lordship feels better.
Yes, yes.
Yes. Before Lordship looks at it, well, my first point is this. Once a law of the land is declared by the Honorable Supreme Court, what is the effect of it? Keeping in mind two dates. Date number 1, September 2022, the writ petition was filed. Precise date is 12th of September 22, the writ petition was filed. And the Honorable Single Judge's order is 12th of May 23. The consistent view of the Honorable Supreme Courts, as I have brought 3 settled principle, when a writ petition is filed, the litigators, everyone's right is crystallized the day the litigation is filed. Precise citation on that is rights of the 2003 1 SCC 726, paragraph 7. Hmm. 2003 1 SCC 726, paragraph 7. The short portion. Having heard the learned counsel for the appellant as also the learned counsel for the state and the private respondents, we are satisfied that the appeal deserves to be allowed. The ordinary rule of litigation is that the rights of the parties stand crystallized on the date of commencement of litigation. Lordship may kindly. And the right to relief should be decided by reference to the date on which the petitioner entered the portals of the court. A petitioner, though entitled to relief in law, may yet be denied relief in equity because of subsequent or intervening events. That is the events between the commencement of the litigations and the date of decision. The rest portions, I need not. I am only on the point of crystallization of the right of the writ petitioner in September 2022. Now this point, as I said, it is a very consistent view. It is our court. It was by Honorable Justice Dipankar Datta's judgment, sitting in the division bench, 2018 SCC Online, Calcutta, 12185. 2018 SCC Online, Calcutta, 12185, paragraph 5. This is even tweaks little bit. that it is not only from the date of crystallizations, one may not even get the relief if in the intervening period anything happens. Paragraph 5. Law is well settled that although ordinarily right to relief relates back to the date of institution of the proceedings, that is crystallization in September 22, the remedy of a writ being discretionary, in an appropriate case, relief may be declined if during the pendency of the proceedings before the writ court, there is a change of law which makes the relief incapable of being granted. The same thing has also been echoed by the Honorable Supreme Court. This is the last judgment on this. 2020 9 SCC, page 1. 2020 9 SCC, page 1, paragraph 101. This on the point, if there is a change of law, an appeal is pending, there is a requirement of take note of that change by the Honorable Appellate Court.
Yes.
Paragraph 101, well, this is a quote from the another judgment. In Lakshminaran Gui versus such and such, it was laid down that change in law during the pendency of the appeal has to be taken into consideration. Thus, that a change in law during the pendency of an appeal has to be taken, practically the same thing. Lordship may keep that. Thereafter, just under 10. If the new law speaks in language which expressly or be clear, interdependent, takes in event pending matters, the court of trial as well as the court of appeal must have regard to an intention so expressed, and the court of appeal may give effect to such a law even after the judgment of the court of first instance. My first fundamental point is this. 2016 rule 6.2 and 6.3 has been interpreted by the Honorable Supreme Court in April 2025 in two clear categories. Before saying anything, I will show 3 paragraphs. Thereafter, I would say what, my lord, what is my submission. Kindly take, my lord. Kindly take my note.
Yes. Which judgment you are?
Yes, my lord.
Note.
Note. The note contains, my lord, the formulation which is directly taken from the Honorable Supreme Courts.
Yes.
Yes, my lord, I say that 2025, kindly see Roman 1, 2 categories have been formed by this judgment. True, after the single bench judgment, correct. That is, one is just an untrained candidate who are the writ petitioners and who could not get themselves trained by April 2019, which is one of the most important dates. And Lordship, straightway kindly come to paragraph 26. 3 paragraphs I would be relying, 2 for us and 1 for them. Plus 26 of 2025 is Lordship has copy of the judgment. I have extra copies also.
2025.
The last question I gave, but there is no difficulty. But I brought the another extra copies. Lordship need not waste any time. There are copies. 25, SCC online, SC 722. 722? Yeah. 722. Justice Gawai. Yes. Well, before placing the judgment, my respectful submission is this. By this judgment, which is, my lord, which is a law under Article 141 applicable to, as the Honorable Supreme Court held, for more than 12 lakhs pan-India, a window was created and recognized by the Honorable Supreme Court having three fundamental pillars of the window. If anyone fulfills the three conditions of the window, as I said metaphorically, he becomes a butterfly. Well, I am using the caterpillar as an untrained and butterfly as a trained. The Honorable Supreme Court's law.
Mr. Dhar, what is the point you are arguing? Reference to what? All right, crystallized on the date of filing writ petition. Then
Yes.
what is your argument?
My argument is this: by virtue of the Supreme Court judgment, once the conditions are fulfilled by April 2019, that is pre-filing of the writ petition.
Where do you find that date? April 2019?
Yes, that date can be found paragraph 26.
Of what? Paragraph 26 of?
Date is one pillar of the window.
Paragraph 20.
Paragraph 26 of Kaushik.
What you are arguing?
I am arguing
Go
this.
to metaphorical examples. Tell us what you are arguing.
My submission is this. The basic premise of the learned single judge was, we are untrained.
Yes.
And
some
others are trained.
Yes.
So around 10,000 trained.
Trained is not involved in.
Yes, I'm saying. So we are untrained.
You are untrained.
At the time of recruitment. That was the premise. And therefore, no protection to us because we were untrained. That's the premise of the judgment. Because we were untrained and because corruption happened as perceived by the Honorable Single Judge, therefore untrained candidates do not deserve any justice or equity. Their termination is the right course of action. And following action, what should be done? That was the basic premise. The judgment of the Honorable Single Judge has two categories. I am not touching the trend, clearly said. Irrespective of the fact that interview, test, whatever, though I have all my independent points that this is just a perception, not correct. Irrespective of the fact, everything was in the similar manner. But because at the time of recruitment, under Rule 6.3, I was an untrained candidate.
Yes.
Admittedly.
Yes.
So that was the premise of the Honorable Single Judge to make a distinction between trained and untrained.
How does that affect you?
Yes. If I put
you are also untrained people.
I am untrained,
yes.
But I am no more untrained after 19th April 2019. That is the law of the land declared by the Honorable Supreme Court. After setting aside the judgment of our court.
It is not the ground of the cancellation of the appointment.
Exactly. That's my
then
point.
Why you are arguing that?
I am arguing because the writ petition was not filed.
Petition said that I am untrained.
Yes.
You are untrained.
Yes.
You have been favorably dealt with by the board.
But when the writ petition is saying so.
That was in September 2020.
Yes.
Now whatever right crystallized in your favor, we are not on that. You are asking us to examine whether the direction for cancellation was justified.
Absolutely. Kindly look at this way.
So please make it within those parameters.
I am coming to that. Kindly see that. This is most likely, unless I am missing, either I am missing completely or there is such a fundamental point which has been missed completely by the... Allow me to reframe it. All I am saying, by virtue of the Honorable Supreme Court judgment, which is the law of the land, kindly forget it that I understand this law of the land was declared in April 25, but Lordship is hearing today. Lordships may not ignore this judgment. And this judgment, Supreme Court clearly held that by 19th April, I ceased to be an untrained. I was surprised when I read it. That was my first reaction. I know I'm doing something like adventuring because this point was never been there. Of course, it was never been there. But
now, then what is the analogy? Then after April, what is your character now?
Yes, after April, if I fulfill those three conditions, the condition number one, that I have to be in service by August 2017. That's the Honorable Supreme Court held. Condition number two, during service, I have to complete that through NIOS only. And third condition is, I have to complete that course by 19th of April. And thereafter, the Honorable Supreme Court said, anybody who is not fulfilling or fulfilling only one condition of fulfilling after April 19, he will not get this benefit. Effect is after April 19, because of the fulfillment of these three conditions, declaration of the Honorable Supreme Court is, you become at par with the trained. That is what Rule 6.3 of ours. Or I would have faced the dismissal. Now, this declaration.
Have they made this point in their writ petition?
No, why they will make? They will not make it. I say that, kindly visualize this way. They filed the writ petition in September 2022. Now in September 2022,
your contention is by the cutoff date, I have now become a trained candidate. I have been appointed. Untrained cannot disturb my appointment because now at this juncture I am trained. That is your argument.
Yes, plus by the same judgment, the Honorable Single Judge has said, I am not touching trained candidates who were trained at the time of recruitment.
Yes.
Now,
all right, your argument is by the cutoff date I have become trained. You cannot challenge my appointed now in this course, in these facts.
By telling me that you are an untrained, all I'm trying to say that had the writ petition being filed before myself become,
paragraph
yes, paragraph 26, 3 paragraphs. Kindly see 26 first.
Yes.
Well, this is, Lordship has got 26.
Yes.
It can thus be seen that this court observed that since the time gap between the direction issued by the central government and 31st March 19 was only about 18 months, the period of the course was reduced from 2 years to 18 months. It can further be seen that this court recorded that around 12 lakhs, such and such, in-service elementary, in fact, we also fall under 12 lakh, elementary teachers had registered and made payment on the NIOS portal as on 30th September 17. Not only that, but this court also observed that the NCT recognition order dated 22nd September 17 was, kindly mark this, only for those untrained in-service teachers in governmental aided, unaided private schools who were appointed or not before this condition, 10th August 17. So anybody after 10th August, no. Pertinently, this court observed that the entire scheme was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualifications prior to 1st April 19, they could not have continued to remain in service and would have faced dismissal. Kindly thereafter see 33. Or before 33, sorry, paragraph 28, last sentence. Writ petition would be attracted under that. Because there is the direction by the Honorable Single Judge, hold another examinations, giving them time to do the training, which is completely contrary to 28. 28, last sentence. Any other candidate who was not in service as on 10th August 17, that is writ petitioners, cannot be considered to be at par with the 2 years DLED. Kindly come to 33 thereafter. As observed herein before, as observed herein before, it is clear that the judgment of this court in the case of Jaivi Singh unequivocally held that the entire scheme emanating from the NCT recognition order dated such and such was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to April 2019, they would not have continued to remain in service and would have faced dismissal from service. As such, this is the condition. Any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to 1st April 19 is a valid diploma holder and at par with any other teacher who has been completed the 2 years DLED program. My respectful submission is this. Had the writ petition been filed prior to 19, no difficulty.
Have you taken? You couldn't have taken this ground in the appeal.
But that is.
You are now going beyond that.
Your Lordship.
New points.
Yes. Your Lordship.
This is not the subject. You have not taken this ground in the appeal.
May I say this? May I say this? Would your Lordship genuinely think that I should not take this point? Then I will not say any single word.
That is choice is up to you, Mr. Dhar. You are arguing something
a law
not there.
May I say this?
Not even there in your appeal.
No, that is there. May I say this? May I say
where is it? Show us one ground that you had a premeditation that Supreme Court in future years will decide.
Kindly allow this. Kindly allow.
Unnecessarily elongating the issue.
This is not unnecessary.
This is because that is one say you are saying your writ petitioners have not pleaded anything and they are taking this.
May I say
now you are saying that no, though I have not pleaded, I will take this.
No. Kindly allow me to say what I'm.
We have allowed you. Come to the next point.
But I will come. But I have not finished this point. Lordship.
We understood.
But I am not join the practice for 1 year and I will take all the irrational things. Lordship is dealing with the lives of about 2 lakhs persons.
Please don't remind us of our duty and obligation.
So kindly.
We have put you a question, you have failed to answer that. But still we have heard you on that point. You proceed to your next point.
I'm answering to Lordship's query. Lordship's query whether I have taken this point or not. Kindly see the date of the judgment. Yes. It was of April 25.
You could not have taken.
So therefore, we don't have a time machine.
So then why you
we were not even parties.
Point?
Kindly look at this way. No, Lordship, this is unfair. I was not made as a party. I had to go before the Honorable Supreme Court. Supreme Court directed that all contentions have to be made. In the meantime, Supreme Court declared a law. Lordship do not want to see it. Can this be a law? Can this be a law?
What we are doing?
My interpretation, kindly see, my interpretation may be wrong, but to tell me, go back to the time machine, this judgment was delivered in April. I am trying to get the benefit of the judgment.
Don't misquote us.
Yes.
This point you raised on the earlier occasion also.
This
he said, Mr. Dhar,
yes.
Please restrict yourself on the basis of the materials which are there. You insisted that I should put this point. You have put your point. We have taken note. Finished. Come to the next.
I have taken this point in a sense that under 6, can you take the rule, my lord? Can you take the rule itself? Because this is not that something new has come up by the Supreme Court. It was there very much part and parcel of the rule. Every time my endeavor is this. Kindly, my lord, I may not be able to, my lord, express myself. But my endeavor is this, that once a litigation is filed, then rights of the litigators is of that date itself, and that is 22. And the window created by the Supreme Court based on the NCT several orders, that window is finished by 19. Now, before the learned single bench, this judgment was not there because there was a contrary view in present. But today, all over India, every teacher who are appointed and fulfilling these three conditions, they are treated at par because of paragraph 33.
We understood you.
And
what more you have to
now, Lordship, may kindly look at this. Kindly see this. Kindly take, my lord, the copy of the rule, possibly with your lordship. Kindly take the rule. Rule 6.2 and 6.3. Copy of rule.
That has to be done within 2 years.
Because that this is directly recognition of rule 6.3.
Yes.
Because
by rule 6.3, they have completed, they have those appointed, they have completed the check.
But we did not have any seal of the Honorable Supreme Court. All I'm trying to say that we did not have a seal of the Honorable Supreme Court of at par. Now that seal came in 2025, which has a retrospective effect in understanding of the law before a Honorable Division Bench, when this Honorable Division Bench is deciding. This is my point. My first three judgments was that this is during pendency.
Yes.
This, well, copy of the rule, Lordship might be having this.
It is out.
2016. Well, I have a separate copy also. Lordship might have marked.
Yes. Yes.
Yes, Lordship, kindly see 6.2. I'm not reading entirely because it has been read several, only the last line. Read with relaxed qualification issued by the ministry from time to time and past 38. So, and 6.3, that 2 years.
Yes.
So I will conclude this point by after saying this. So Lordship may kindly think this, that there was an existence of contingent condition to be fulfilled under 6.3. I have fulfilled by April 19. Having fulfilled by April 19, there I use my metaphor, I have become a butterfly, no more a caterpillar. But the single judge has treated me as a caterpillar.
Yes.
That is wrong because of paragraph, Lordship, kindly take the paragraph 22 of the Honorable Single Judge's order. It goes directly contrary to this, the law declared by the Supreme Court. Kindly take paragraph 22 at page 624 in the paper book.
Yes, read it. Third.
Paragraph 22 runs completely contrary to paragraph 28 of Kaushik. Because paragraph 28, the Honorable Supreme Court had held, this is only available subject to fulfillment of three conditions. But here the learned single judge gives a separate condition. Kindly look at, the board shall immediately arrange for a recruitment exercise for candidates who are untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime, within a period of 3 months from date. This is totally going contrary. From date only for the candidates who participated in 16. Kindly have a look at paragraph 28 of Kaushik. So therefore, learned single judge gives time, even 3 months more, much after 19.
Yes.
Kindly take the one sentence of paragraph 28. The last sentence of 28.
Yes.
Any other candidate who was not in service, that's a writ petitioner, on 10th August 17 cannot be considered to be at par with the 2 years DLED. So therefore, window was there, 3 conditions were there, it is sealed. Nobody after April 19 cannot make himself trained. Not possible as long as this judgment stands. I am over on first point. My second point. If I use this word, the Honorable Single Judge completely ignored the statutory word natural in Rule 2C of teaching test. Kindly see 2C. Is never a test.
Yes.
Well, my second point is the Honorable Single Judge completely ignored a particular word in the definition of 2C, which changes the entire color of this. Kindly see 2C. 2C never says about the aptitude test. It's a natural. First Lordship, take it.
Yes.
Well, a definition is aptitude test means a test, kindly mark, to assess natural teaching ability of a candidate. It is not a separate test at all. Kindly take the examples of we often have in our college, the extempo debate competitions, where the judges take a decisions based on assessment of overall presentations, content, maybe oratory. So assessment has to be under 2 categories: viva voce and the natural ability of a candidate. Sorry, natural teaching ability. Well, I was trying to understand what does it mean of the natural, because what's the difference between? Lordship kindly takes the blacks. Lordship may take us a very, very common understanding while Lordship hears out the matter from the advocates. There are content, there are laws. Lordship looks into that. Simultaneously, Lordship also sees. I think this is a very, 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 as a Homo sapiens, we get that. The natural ability of the person, whether to communicate or not. So my submission is, it should be one test. In the test, there would be questions. While the interviewee answering the question, the interviewer would, in addition to the correctness of content, also assess, does he have a natural ability to teach? That's what 2C says. Lordship, may kindly have a look at the definition of this. In black.
Did your interviewers understand this?
Well, I will satisfy your Lordship.
Tested by persons who had not even qualified to understand that much of
Well,
things.
they understood. But one of the examples, Lordship may be shocked. Lordship may be
an argument. Now you kindly go through the definition, and definition will show that it is not a segregated test, interview and aptitude was said, it is only the nature of question which was put is to be different.
It is to be segregated assessment. Kindly visualize. I don't say that there should not be any test for natural ability. I don't say so.
We are asking you, was this done?
It was done. I will show from the evidence also.
It was
Lordship would be surprised. On every fact, I shall be satisfying your Lordship's conscience. I am not going to take any technical points. Kaushik was, of course, maybe a technical point. But most likely, I would be able to persuade your Lordships that on fact.
What is your argument
Yes.
to that? That interview and aptitude have to be taken in a composite manner?
I say this. How a natural ability can be assessed? Kindly visualize.
You tell us.
Yes. I say that if a test is exclusively for a test for judging natural ability, then you kill the naturality of it. Kindly think over it. Lordships are testing the lawyers. Whether Lordships require a separate test for the lawyers to understand the natural ability to communicate, or that is in the process in
Mr. Dhar, primary teacher applicants, they will understand so much. Your interviewers will answer
this is nothing
and
to
you
do
are
with
asking us to go into the issue, the manner in which you understand the definition.
I'm saying that
it's unfortunate.
No, I'm not.
You are bringing in points which your board interviewers did not have that amount of intelligence, so to say, as you are arguing in this matter.
No,
Now
not.
you are just because you are the arguing counsel.
No.
Whichever things you think
They
that is
understood it.
affecting my conscience.
They understood it correctly, but they were not able to communicate it. They may not be able to say that as I am saying.
So you cannot communicate afresh on their part.
No, I will not communicate.
Please don't do it. You restrict yourself on the ground of challenge.
I am restricting, my lord. I am not making submissions which are not relevant. Kindly visualize this. Lordship has seen in the judgment anywhere that word natural has been used by the Honorable Single Judge.
Don't do post question to us. You make your argument.
I say that, sorry, that was my mistake. Sorry, extremely sorry. My lord, the Honorable Single Judge, sometimes I'm so sorry. I shouldn't have. My lord, the Honorable Single Judge in the entire judgment has not used the very definition of aptitude test. Two things are different. Assessment of aptitude test not done is one thing. An aptitude test has to be a completely separate test altogether is a different thing.
So you say they are intermingled.
Yes, because I also give an answer. Because preservation of the naturality. My lord, when someone is answering questions, kindly look at this way, my lord. There has to be certain amount of subjectiveness, or I can use arbitrariness. Subjectiveness is a better word. When a question is asked on geography, on history, on English, on anything else, if the answer happened to be the same, like a quiz contest, but how that answer is given, if the persons who are taking the interview, if they understand it, that's the natural ability. They would be the best person to assess it. Therefore, there has to be an assessment. Absolutely right, the Honorable Single Judge on that. But to say that, no, there should be a separate test altogether, like a separate day, separate test, that is incorrect.
That the court has not said. Separate day it should be held, it has not.
Court has said there was no aptitude test.
That is one thing of it. That aptitude has to be taken in a separate date. This was never the picture.
But that the Lordship kindly take it.
Judge proceeded on the basis that when there are two faculties of mark giving, 5 for interview,
Lordship
5 for
may be shocked in the process that the Honorable Single Judge has proceeded. Kindly come to page 615. A person was called, his English was not good, and the judge terminated his service there and there by a judicial order. At least in my last 28 years of practice, I have never ever come across this. Do I need to spend one sentence to say that this is so unjust? A person who is not a petitioner, who is not a candidate, who is nobody, he is called, his English was poor. So how many of us would actually lose our license?
The ground of challenge. That is not the ground of challenge.
Need not be. But that's the basis of 615.
Don't go into the conduct and the manner it was done.
I am not going. Kindly come to 600.
Well, you point out the action, all right.
Yes.
Please don't go
I'm
beyond.
but that has been taken note of. Kindly take it.
The court had been unreasonable according to you. Finished?
No,
Court
it,
had
but,
been
if it is, well, if it is,
person doesn't know English, if he said that go, I am terminating your.
if I finish in that way, then I actually finish. I am trying to survive.
What?
Kindly have some mercy also on us. There are two sides. There are both sides of a story. Possible that my story is not good enough.
Yes.
Kindly take 650.
It is also.
Kindly take two notes. There were 700 interviewers.
700 interviewers.
Total, approximately.
Where did you get that figure from?
I don't have, but I don't think.
Nowhere it is there. Yes.
But there has to be a number, but Lordship, for understanding that 30 of the,
Which page you are referring? Page?
Page 615. 30 persons were called.
650.
Yes.
Yes.
Now, Lordship may kindly first mark, I have calculated who said what, and what I have found out of 30, going by the exactly recording of the judge, out of 30, 13 said no aptitude test. Kindly take number 1. Did he say that there was no assessment of the aptitude, natural ability? He didn't say so. He said there was no aptitude test because any common persons will understand aptitude test itself as if a separate test. So out of 30, 13% said no aptitude test. Kindly come to serial number 16. That's the reason I said this. Serial number 16 was Mr. Tushar Kanti Das, the unfortunate gentleman whose English was poor. By a judicial order, he lost his service. And that is not, and that is page 616. Kindly see, the recording is evidence on the real question was not taken for special reason. Most likely, Lordship will kindly take my serial number 16. Tushar Kanti Das, what is the evidence on the real question was not taken for special reason. Lordship has seen that. Now kindly see what is the reason, page 537.
Yes.
The reason was this teacher understands very little. He is a teacher of a secondary school. Kindly see, I find him wholly unfit for teaching job in a school. He has clearly stated that he does not know English. I do not know how he will develop teaching ability. Incidentally, he was a game teacher. Ability to teach a student. Hence, I recommend the West Bengal Board of Secondary Education to terminate the job of the deponent forthwith. If I have to spend one more sentence on this to say this is injustice, I feel extremely sad about it. A witness, no way connected with the case, was not able to, in fact, I got the judgments by the Honorable Supreme Court saying if somebody is not good in English, do not deprecate that. We are living in a federal structure. There are villages. Not everyone gets an urban education. And there we have.
What you are meaning to say, Mr.
I am meaning to say that
the judge was unreasonable. What is your argument, sir?
Do I have to? I say this. Yes, I borrow your lordship's word.
So if you say that this is an unreasonability, all right.
There is an unreasonability of a.
If for unreasonability you go for a predisposition.
No.
Then it becomes a bit.
May I say what I say? Can you see? I say that on a scale of unreasonability of 0 to 1000, it falls under category of 900 and plus. Had it been an unreasonableness of 0 to 100, possibly I would have ignored it.
Understand the backdrop in which it is being.
No, he is not a candidate. He is not a corrupt person.
How does that affect you?
It affects. Kindly come to 615.
Somebody has given me less numbers in the examination. If that is challenged.
No.
If the principal of the school is sent for termination, what effect does it have?
May I explain how? Affectation is this. I decide the rules. I decide what should be the question. I don't read to see. I forget about the naturality of the test. So I ask a question, was there an aptitude test? So that is a fundamentally flawed question.
Very good. That will be your argument.
Now, while I do...
fundamentally flawed questions were put to the interviewers. Finished.
Well, it is...
Kindly see the conduct of the judge. Why for that reason, one word, person terminated, not knowing English is not a requirement. I will cite Supreme Court judgments so that is beyond the scope and ambit of this matter. Sorry, but we are expressing ourselves.
No, that is the best way to express. Well,
it is not that we are shunning you out from the.
No, I understand. Well, I understand. There is absolutely no difficulty. I say this.
Yes.
That kindly look at this and kindly connect the dots.
Citing these problems in.
Yes, I'm connecting. There is
your argument?
Yes. My argument is this: 30 persons were called. Now, out of 30, it is only 13 said no aptitude test. What about the 17? Why the Honorable Single Judge did not say anything about the 17? So, therefore, first I take it from 700. It is my own sample. It is my own question. And it is also my own angle and perception I am putting into the whole perspective. And say this is a corruption. I could have understood that the Honorable Single Judge said out of 30, 17 of them. Kindly look at their deposition. I have read each of the depositions.
Yes.
This is the deposition. 615. Yes. Kindly see the serial number 2. Aptitude test was taken. Why the Honorable Single Judge, my question is this, did not give any reliance on serial number 2? Even going by the pure mathematics also, he is ignoring the majority. Kindly see serial number 4. Aptitude test was taken, but no separate question for interview or aptitude test. Fundamentally, what I am trying to say, one interview, in the interview, assessment of aptitude, natural ability, and nothing else, not a separate test. Kindly see serial number 6. Aptitude test was taken. Kindly see serial number 10. Aptitude test was taken, but no guideline was there. Then serial number 12. Interview was for 10 marks, but said aptitude was taken. Serial number 14. Aptitude test was taken. No guidelines were given. Serial number 16. That gentleman who lost service.
Come to Rule 4, Sub-Rule 5.
Yes.
With the approval, got it?
Yes, I'm coming.
Place it.
Rule 4,
Sub-Rule 5. Any such modality or procedure or guideline was framed?
Well, here, Lordship is referring with prior approval of the state government.
The board shall have the following power.
To lay down the modalities, procedures or guidelines as the case may be.
Or any modalities laid down. Do you know that?
But here I have submission. Kindly consider.
No, we are asking, do you know any such modality has been laid down?
From the evidence, I find no.
We are not on that. We are saying, yes, any such modality was there.
Well, there was a guideline sent to the interviewers, those who are interviewed from the board.
Where is that? That is not on record.
Not on record. Not on record. But there is, I have seen, I can show it to your Lordship. All right.
But Lordship may kindly, I have one Lordship may kindly consider this. I thought it has. If someone has to decide the natural ability, is it not very intangible?
Yes.
Because that would depend on the emotional quotient of the persons. Because how, kindly visualize that, how a person would be able to teach in a natural way. Meaning thereby, how one person's possibly, this is purely my subjective understanding, whose sayings would be more like a storyteller, so that children would actually listen, because storytelling is the best way of absorbing. That even the science also recognizes that. So,
yes,
can there be any guideline to assess that? Answer could be yes, answer could be no. But having participated, I don't need to say any sentence on that. In 2016, in 2022, saying there was no guideline for that. But learned judge, the order is based on not on that. Learned judge is, there was no aptitude test. So my first submission is even the evidence of the honorable judge, majority said there was aptitude test. And those who did say there was no aptitude test, it is my explanations, they understood aptitude it to be a separate test.
All right.
So forming of a question possibly should have been whether there was any assessment. This is
assessment of natural ability.
Yes. Which I feel, I don't know, I tried also that if someone tells me, how do you assess about any of your juniors, whether he has a natural ability to express better? How do I assess it? I assess in my everyday life, when I talk to him, whatever I do, because that's a very intangible thing. Lordships also do that. Somebody might have a good understanding of law, but lordships, in a very intangible process, assess the natural ability of someone who tells whatever thing.
Yes.
Well, my third point. Huge absurd marking.
Pardon?
Huge absurd marking.
You put it here.
Yes, that is in the note also. I'm coming to.
Yes.
This is at page 3. Well, before I say anything on that, kindly visualize this. I believe, my lord, in this courtroom now, approximately, I don't know, maybe 100 persons are there. It could be huge because in every matter, not so many persons remain. But the same persons in Eden Gardens, it's not huge, it's negligible. So what the honorable judge has done, he has expressed his perception without the perspective. I have taken the exact figures of the Honorable Judge. Honorable Judge's finding is about 5,000 persons got more marks in the orally and they were not good in academics. I will give the figures.
5,000.
I have exactly calculated. I found it was
In the order.
First parallel.
in paragraph 14. Lordship, kindly come to paragraph 14.
Yes.
May I just place this part? Now I give example of a candidate before giving a table prepared from the document on record.
They are 33 persons.
Yes.
53 persons, sorry.
No, I don't take 53. I take the full. These figures have been taken from page 238 to 358. And I have calculated the entire figure becomes entire examination 5,216 persons were academically poor. That's from record. Lordship will get it from page 238 because the Honorable Single Judge has taken a sample from that. The whole figure in the entire examinations out of 42,000 from 12 lakhs.
12 lakhs was what?
Sorry, not 12 lakhs.
1 lakh 25.
Sorry. Sorry, 1 lakh 25. Sorry. 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 It was.
Once questions are put to you, you become temperament changes. Why, Mr. Dhar?
I shouldn't.
Such a you're now.
I repent. I repent.
We will prick you.
I repent.
We will prick you. So that you come.
No, I
with the
repent.
right
I realized it. And
we have a right to do that.
True.
Because we are in the same.
No, because no, I don't know. By saying more sorry will not do.
It's always there. We were also on the other side of the.
But sometimes what happens?
No, don't tense yourself.
I understand. True. But sometimes this process, what happens? My lord, may I say this? This is 30 seconds digression. 30-second digressions.
That is because
my lord, no matter how much we put an effort, maybe we become expert also. Sometimes, maybe we also are so emotional being.
No.
Shouldn't. Yes, shouldn't.
Yes, page 238, you show us.
Yes. Page 238. May I just, my lord,
14%. Not 1 lakh 25. So it is the total application. 5216 out of 40 to 929. সেখানে percentage অনেক বেড়ে যাচ্ছে 12.14%.
No, your note says page out of 42,949. That was the appointed.
May I just, because Lordship need not enter into entire part of it. I am trying to say the perception of the Honorable Single Judge was huge. Now the huge should have some meaning in a perspective. In 42,000, 5,000 is about 12%. So meaning thereby 12% in the whole examinations, they were academically not so good. But verbally they are good. In fact, I found many of those 5,000, they are even more than 50%. I take the all figures without any deductions. And then in an examination, so what is the other perspective? 88%. Look at this. 88% in the entire examination going by the facts and figures of the writ petitioners and the Honorable Single Judge, all were academically better.
Yes.
So therefore, the moment Lordship gets the picture that actually 88% are academically better, then to say it is huge is incorrect because there are consistent judgment of the Honorable Supreme Court. Even not judgment, Lordship, I think this is a very common thing. We know many of us, I would say it may be more than 12%, we are able to speak, we are able to formulate, we are able to analyze, but academically we may not be good. So here only 12% of them, they are not academically that good. So 88% even academically good, even orally good.
Yes.
On that point, kindly take, my lord, this 2024 judgment. 2024 7 SCC 262. Okay.
This was placed by Mr. Dotto, I think.
This
24/7 SCC, Obhimit.
On this,
Anyway, you give us.
I will just touch upon them. Well, the paragraph that I would be relying on, that's I have quoted it. So till the time, my lord, that my copies come, may I just refer from that? So paragraph 87, my lord, this I was only that written test cannot possibly capture the full spectrum of the individual's abilities and potential. An interview can also provide a medium for marginalized candidates. Well, here comes that. In fact, that judgments that someone not knowing English for marginalized candidates to showcase their talents in ways which a written test may not be possibly allowed. And 90, an interview unveils the essence of a candidate, their personality, passion, potential. These are very much, my lord, very much intangible, very difficult to find out. And then let's move to the next judgment. 2006, 6 SCC 395, paragraph 54. (2006) 6 SCC 395, paragraph 54.
Yes.
Kindly see paragraph 54. In our opinion, the interview is the best mode of assessing the suitability of a candidate for a particular position. While the written examination will testify the candidate's academic knowledge, the oral test alone can bring out or disclose his overall intellectual and personal qualities like alertness, resourcefulness, dependability, capacity for discussion, ability to take decisions. Let me kindly mark this. Here, the ability to teach naturally, qualities of leadership, etc., which are also essential for a judicial officer. This was in the context of a judicial officer. It has to be much, much higher, but the principle. Then paragraph 55. Paragraph 55, well, from page 420 in Placitum D. It is now well recognized that while a written examination assesses a candidate's knowledge and intellectual ability, an interview test is valuable to assess a candidate's overall intellectual and personal qualities. While a written examination has certain distinct advantage over the interview test, there are yet no written tests which can evaluate a candidate's initiative, alertness, resourcefulness, dependableness, cooperativeness, capacity for clear and logical presentation, effectiveness in discussion, effectiveness in meeting and dealing with others, adaptability, judgment, ability to make decision, ability to lead, intellectual and moral integrity. But thereafter, while we do feel that marks allotted for interview are on the high side, and it may be appropriate for the government to re-examine the question, we are unable to uphold the contention that it was not within the power of the government to provide such high marks for interview or that there was any arbitrary exercise of power. In this case, high marks is not the allegation. In this case, this is also not the allegation that huge. That means the opposite. That is the reverse. That 88% they are academically bad. So fact, which is not the perception, just the perspective is that 88% academically good, orally good. 12% academically not good. So therefore, based on this, to say huge, my humble submission before your lordships is only a perception, leaving the perspective of the matter. It is like saying 100% Eden Gardens, so it's Eden Gardens is full. Same thing. Kindly validate my next point. This is page 5. Well, there was an opposition filed in this same appeal. This was the AO by Priyanka Naskar. That was also, that copy was also referred, part of the record, also referred by Mr. Anindra Mitra. If Lordship kindly take page 14 of that.
Page 14 of what?
This is
page 14 of?
Page 14 of the AO filed by the writ petitioners in this appeal. No?
This appeal means 873.
Yes, 873.
873 opposition. 873.
Well, as a backup, I have had a spiral separately, but this is part of the record.
Don't give us any further papers. We have
Yes, I also think that that should not. What about 14, 15? Ready?
AO by?
Yes. Well, this is
403.
No, page 14.
14.
14.
Of 873.
Page 14 of 873, but not the paper book itself. I am saying
no, paper book when
it is not part of the paper book. It was the part of the opposition filed to the stay application. And this was also seen by your lord, possibly in a spiral. It was affirmed by Priyanka Naskar. It is not in spiral.
Normal, not in spiral. Cannot be in spiral.
তোমাদের spiral? এখানে একটা না এটা নয় এটা ওটাতে নেই এটা আনমার্কড যেটা দিয়েছিল
Let Mr. Mitra give also had given this in a spiral, possibly for convenience.
Yes,
page 14.
Page 14 is the memo.
But is it a
Page
letter?
14 or para 14?
Page 14. Lordship may take my spiral. No.
We won't be able to keep track. No, this is the problem. Affidavit in opposition of the respondent writ petitioners to the
Priyanka Naskar.
Priyanka Naskar, yes. Priyanka Naskar. Mala, there is a chart from page 15.
Yes.
Yeah, that is. I would be showing the chart itself. How the chart begins for that 14. But basically, my whole endeavor would be on chart.
Yes.
Well, same document, Lordships might be required to see side by side. I have done my homework. Page 15 and page 20. So it may not be possible physically to keep it. Page 20 I have separately taken so that side by side Lordship may can see for same document. This is page 20. Just keep it side so that Lordship will not have to go. Malad, this is the chart. What is the chart? That is there at page 14. Can you have a look at this? Writ petitioners breakup of their marks in their respective medium, category and district. Now kindly come 15. My lord, this 03, that's a code, that is Coach Bihar. Deepak Chaudhary is the writ petitioner number 37. He got 12.687. And from page 20, Lordship will see the last mark was 16.607 in his category. By saying his category means in Bengali, in district Coach Bihar, in unreserved, in OBCB.
That is for para teacher category.
No, Lordship is
Page 20.
Don't see page 20 now. I said 20 only for one purpose later on. Kindly see first page 15.
Yes.
Page 15,
12.6.
Deepak Chaudhary Lordship has got. Deepak, kindly mark Deepak Chaudhary is writ petitioner number 37. All our names are writ petitioners. I have marked who are at what number. So Deepak Chaudhary, petitioner number 37, belonging to Coach Bihar. 03 is Coach Bihar. Subject is Bengali. Category is unreserved. OBCB. He obtained 12.687. And in his category, the last person obtained 16.607. That can be found from page 20.
Yes, from that, what we are to understand?
Let me give 3-4 examples. There are second 04, that is Uttar Dinajpur. Category is Bengali. Nimai Ghosh, petitioner number 121. Unreserved, OBCB. He got 13.606, whereas the last person who has been appointed, that person got 13.796. So that way, my lord, I have done my homework for each of the petitioners. And right hand side.
So you got 13.606. And
Not me, writ petitioner.
Nimai Ghosh.
Yes.
Now
He
the
got
last person in that category got
13.796.
that is more than 13.
Exactly. That's the reason he was not appointed. So that's the clarity, no corruption. The percept. Para teacher
is the last person appointed. In Tona appointment finds to district of
The last person you are showing, that is of Tomolika Kundu.
What has happened?
That is in the para teacher.
Exactly. And that is a separate category altogether.
Yes. Very good. Now
There are hundreds of separate categories.
no, this is a mismatch which has not been gone into by the judge.
It is not a mismatch. It is an incorrectness in the understanding of the honorable judge by taking one figure of the parity chart and assuming that.
Where is that? He has taken one figure of the parity
Kindly come to impugned order.
Yes. Which paragraph?
Yes, I'm coming. Kindly take paragraph 7. Paragraph 7.
Yes.
From the breakup, the petitioner found and alleged that the particulars given therein are absolutely false, as because the lowest number of impaneled candidates was shown in the report. This is the report as 14.191, whereas throughout West Bengal, 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet of such and such. So 14.191 was obtained by a person in a category called para-teacher. That was understood by the Honorable.
No, 14.191 is teacher. Where do we get it, para teacher?
That page 21. Kindly take my this page. It is there also, but Lordship has to.
This paragraph 7 refers to a tabular sheet which was produced.
This
Where
is
that tabular sheet?
Yeah, this is what Lordship is saying. Kindly take page 21, code number 19 from the bottom, second one.
Yes.
Kindly see the marking 14.191.
Yes.
Kindly see the category. Para teacher. And I have done each. Well, I have taken last night. I have asked my juniors, because I needed 3 persons just to make this comparison. In each category, I found writ petitioners remain unsuccessful by getting lesser marks. The incorrectness is application of a marks of a para teacher irrespective of categories.
Yes.
Only I have done the full, but only for satisfaction of your lordships, 2, 3 I can give. For an example, kindly take just as a random as code 05, 1, 2, 3, 4, fifth. Not fifth, fourth one. Name is Shamsundar Das. 05 means Dokhin Dinajpur. So in Dokhin Dinajpur, unreserved OBC A, he is a petitioner number 48. Shamsundar is 48. Shamsundar got 15.261, but in that category, the last person got 20.179. That's why Shamsundar did not get the job.
Where do we get it? 20?
20. Kindly come to page 20, serial number 3, right hand side. That's the category.
Shamsundar Das.
There are 2 OBC, Shamsundar and Shabina. Shamsundar is petition number 48, Shabina is 49. Both in OBC A. Both one got 15, another 12. But last mark 20.179. Lordship may take the other example of 06, that is Malda. Malda Omar Singh is petition number 64. In fact, there are a good number of in this category. This category is Malda unreserved SC. The last mark was 15.930. And look at their marks of the entire SC.
All right. Yes.
What the Honorable Single Judge has done, Honorable Single Judge has picked up the category from para teacher
And tallied it with the
Yes.
other teachers.
and the advertisement is at page 120. I was not able to read it. 120 of the paper book. Lordship will also not be able to read it. But I have, to the Jumbo Xerox, I have done it. One page has come to 11 pages, but it is nicely readable. This is the advertisement. It gives a so clear look of the variety of categories there. Now, this is the same page, only Xerox, so that it can be readable. This is page 120 of the paper book.
Yes.
These categories from third page. Lordship will see all the code. Like Alipurduar is a code 02. Code is not there. Here district is there. Bakura is 16. But categories Lordship will understand from these boxes. Only for that purpose. So therefore, well, I have checked up myself of each of the categories, and there are 4 areas. Even there are no vacancies because all were filled up by the trained. Because first has to be trained, leftover, it goes to the untrained, not otherwise. I myself have taken note of all. If Lordships want, I can give one page of, and I have found each of the petitioners of 139. Each one of them, they have got lesser marks than the last candidate in that category, which was there. The mistake was picking up the category of the para teacher and spreading over to all.
Yes.
Well, there is a one point I will not say anything because these are the points anybody appearing in the service matters. But I have taken note of, Lordship may refer it, but I will not consume any time for that. My point number 5. I said that having participated in the selection process, being unsuccessful, writ petition is not maintainable, particularly when filed after a lapse of 4 years, 7 months from expiry of the panel and 5 years, 4 months from approval of the panel.
When was the appointment made? When it was in 2000?
In February, March 17. That is the one of the window conditions that I said.
February to March?
February, March 2017. And writ petition was filed
September 20.
Yes, September 22.
Yes.
Well, there are 4 judgments. I am not placing that having participated after so many years, paragraphs are also there. I am not saying anything on that. Now, my lord, my submission is kindly take my lord 165. Kindly take this. No, I know, but this has not been. I will not. This has not been. What I'm going to say, this has not been. That's most likely Lordship will see this is new.
Yes.
May I just, my lord, formulate? I will not take much time on that. 1932, there is a judgment saying on 165 that 165 cannot be used in contravention of any of the provisions of the Evidence Act. That's the parameters. Now I find there is a definition of the judge court in the Evidence Act, and under 165, it is the power of the court to put question as opposed to call somebody. And it is in contravention of 137 because 137 clarifies who that. Kindly have a look at just three sections. First, 165.
Evidence Act of
It evidence.
Like this was 20 page 51.
Section 3 defines the court. Sorry.
Yes.
Section 3, the definition clause court. It includes all judges, magistrates, and all persons except arbitrators legally authorized to take evidence. Now kindly come to 165. Kindly see the very beginning of it. Judges' power to put questions. Power to put question is one thing. Power to call, which is controlled by 137, is a different thing.
Yes.
So, judges' power to put questions or order production. The judge may, in order to discover or obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness. Rest need not be read. So I completely agree with the power to put question to a witness. Kindly come to 137.
Yes.
137. The examination of a witness, kindly mark thereafter, by the party. Cross-examination, the examination of a witness by the adverse party. The court is defined under 3. All I am saying, first under 165, power to put question as opposed to call. Next is to who? To a witness. Who is a witness? 137. Two kinds of, by the party or by the adverse party. The whole code, having defined court under 3, not including court there under 137.
Yes.
And maybe that is the reason we were finding so difficult to get any judgment that the Honorable High Court, having exercised 165, has...
Sir, are you suggesting that a court can't call its own witness?
Court can't?
Call a witness.
My lord, if lordship goes by this 137...
137 is restricted to a party calling a witness.
Yes.
But that does not mean that the court can't call for a witness. There is the issue of subpoena.
Yes, yes, yes.
Subpoena is when the court calls for a witness.
Can, but court is calling a witness. But who is a witness?
Anybody.
Now, I say that witness has to be by either of the parties.
That's 137.
137, this
But
party.
there is a provision for subpoena.
Yes, there
You
is.
can subpoena a
Yes,
person to
there is,
open
there is, there is.
Why shouldn't 165 be covered by that?
That's a possible view. It's a possible view. And it's a liberal view. We should tilt towards liberal, but I would say in the context of this case, to call specific number of persons or to choose, that doesn't come under 137. There are other points, but I'm not disputing your lordships. Lordship has taken a very fundamental point. I do not want also that the court be denuded of, I don't want. But here and there, little bit of change of context makes a lot of differences. The first step is whether the court can at all exercise 165 in a writ proceedings. That's the first.
Separate issue.
Yes. If the answer is yes, is it in a...
Apropos your argument that 165 presupposes a witness being there and only then the court can put questions. Apropos that.
Yes.
The court can always summon a witness.
Can.
By way of a subpoena.
I understand. Can. I can't.
And 165 will...
Can. But my submission before your lordship would be, since these codes are more often a very, they are in a very watertight way. So there, and I don't find the word court anywhere in 137 there. Yes, subpoena, agreed. But there is a judgment 1932. Just a second. This one?
Yes, what is your...
Yes.
30
this judgment, sorry.
1930.
Yes, 30. That Rahi Jaddi, 1930 SCC Online, Calcutta. Kindly take. There is, I won't be able to say paragraph, but I can take your lordships too. But there is a very light marking page 1012. Lordship, kindly come to bottom. Second page. 1012. Oh, 191.
Yes.
Kindly take, my lord, second page. On the second page, my lord, somewhere on the top, there is a page 1011.
Yes.
And thereafter, there is 1012, a little above 1012. The judge may ask, well, this is, I quote from Amir Ali and Wood offers law of evidence. The judge may ask any question in any form and at any stage of the case, and to a certain extent even allow parties or the advocates to do so. This, however, does not mean that he can receive illegal evidence at pleasure. For if such be left to the jury, a new trial may be granted, even though the evidence were extracted by questions put from the bench. But it is a power necessary to prevent justice being defeated by technicality to secure indicative evidence, and in criminal cases to assist in fixing the amount of punishment. In the present case, the alleged statements before the police were not properly put in evidence under section 162 of the Code of Criminal Procedure. They were not even proved as substantive evidence. Yet the learned judge made use of them in order to discredit the witness, insofar as he did not support the prosecution case. This he was not entitled to do. I am supported in this case by the case of such and such, where in similar circumstances it was pointed out that Section 2 of the Evidence Act left the provisions of Criminal Procedure Code unaffected, and it was held that, but this part I am relying, power conferred on a judge under Section 165 of the Evidence Act could not be exercised for the purpose of introducing evidence in contravention of the law. In that case, it was 162. Here I am trying to say it is 137. But there is the next judgment is 2013 4 SCC 465. Paragraph 24 and 30.
This has been argued, Mr.
Then I'm not stressing. I'm just
It has
giving.
been argued.
Kindly take this. There are 4 citations. Other was 1957 SCC Online SC 30 paragraph 10. But I have quoted also paragraph, so I'm not taking any time for that. And there is a 75 judgment, 75 2 SCC 557 para 21, 23, 24. There paragraph 21 was on the judicial review and vis-a-vis whether it can be used. And the 2011 10 SCC 249 paragraph 12 and paragraph 13. Well, this is a very settled proposition. And 2019, 2019, well, this is a single bench, so I'm not relying on it. Lordship may leave that. Kobita need not be. And that Ajay Singh, my lord, that is also this two, Roman 4 and 5, I'm not relying. At the time of preparation, I thought, but on a second look, I thought may not be. Well, the
Come
other.
back to that 1110 SCC.
Yes, paragraph 12 and 13.
No, 13, what does it say? In 226 what? That was
So
a case of
it was not fully there. May I just.
That was a case of disciplinary proceeding.
Yes.
What you wanted to say by paragraph 13?
May I come there? Page 7. Well, 13 was, Lordship has read that. Well, there, Lordship has seen the evidence.
No, Mr. Dhar, there is no bar of exercise of 165 and in 226.
Nobody is saying. I have also.
An argument which was advanced was the primary argument, judge cannot act as the prosecutor.
The judge cannot
act as the prosecutor. It was the argument that his lordship himself has put the question without giving opportunity to the person who would be affected by that from cross-examining him. That opportunity was not granted, so you cannot look into that. But in 226, facts and circumstances, 165 can be taken recourse of. Do you have any judgment against that? That in 226 it cannot be done?
My only judgment is this cannot be in contravention of another provision of the Evidence Act.
Again, you are falling back on.
But I have.
There is no pat on the point judgment.
I have searched. There are two things. I have not been able to see a judgment accepting the Honorable Single Judge's this judgment where the Honorable Single Judge has exercised 165. So there is an absence of a proposition of law, meaning thereby, I'm not saying this is correct or wrong. All I'm trying to say, so therefore the constitutional courts possibly thought not to use 165 in usual circumstances. That's why we don't find, because we have searched so much. So there are not number of judgments saying in case of X it can be used or in case of Y it cannot be used. It's a vacuum area minus
we are discussing. No judgment has been shown to us that there can be no application of 165 in 226%. Now, there are spelled out parameters that in A, B, C, D conditions, if arise, just the learned judge has proceeded on the basis there was a large scale corruption. There was a scam.
Correct.
Jobs were sold.
Correct.
So, is that the issue on the basis of which His Lordship exercises 165? That also you cannot totally rule out. It is the perception of the judge.
It is the perception of the judge.
That which you argued that the perspective ought
Yes.
to have been ascertained
Yes,
before
yes.
that.
What I felt, my lord, this is my genuine feeling as a counsel.
Mr.
While
Mitra's
preparing,
argument was that on the rudiments of illegalities and irregularities, you cannot establish a case by exercising 165 that there was a corruption. Corruption has a certain extra amount of element,
yes,
which is different from the mere illegalities and irregularities.
yes, yes.
So that may have been a ground.
True.
We expected that may have been a ground, but in the judgment,
that is.
Why does His Lordship go to that effect? This predisposition which was being urged by Mr. Dotto on the first day. Now, from the judgment, paragraph 17 to 22, His Lordship proceeds on the basis that I need not go into the judgments.
Yes.
They are poor persons, they are jobless.
Yes.
So I take up the role.
Yes.
And I ascertain that yes, there was a.
Yes.
So is there any judgment to that effect that these are the described parameters on which 165 could have been applied?
I have
No
not found.
argument.
I have, in fact, I have asked all my juniors because this is.
So no, then what is your answer to that? What according to you?
What
according to you? Why will a constitutional court
should
is going to that point? Why?
No, there are. If I would say, allow me to say this: law and justice is a living thing which grows. So, as a part of the institution, most likely I will not, I'm saying very subjectively here, I will not make any attempt which goes contrary to this living nature of law and justice. Meaning thereby, what was Article 21 50 years before and what is Article 21 today, there has been a change. For an example, there was a time the conception had been that as if Constitution is providing these rights. But the change is that no, by natural law as a Homo sapiens, there are certain things which cannot be alienated from you. Constitution is only recognizing. It's not a source of birth of your rights. For an example, someone is thinking. That is not that Constitution is giving. So it is constantly, my lord, changing. Keeping in mind the change and the living nature, I would say that today, in the present context, I don't think we have arisen at a stage where Lordship are required to frame up parameters that under these circumstances 165 can be utilized.
Yes. All right.
My lord, then if I can just add two more sentences on that, what I feel is if the perception gets changed, for an example, if the context becomes clear in a proper perspective, that actually it was in a para-teacher, which is a separate category, then, my lord, anybody, even the learned judge would have thought otherwise. So maybe the perception, connecting all these perceptions, starting from the aptitude assessment, vis-a-vis a separate test, and this marking, all connected, one may have a perception that there is a corruption. But when Lordships today is seeing it in a different perspective with all the facts and figures before your Lordships, there may not be any requirement at all to frame up parameters for that. If Lordship finds that this is a case where if there are necessity, no doubt. But my respectful submission that possibly this is not such case. This is not such case where the Lordship would be requiring to frame up parameters under which there is a requirement of the High Court to enter into 165.
Mr. Dhar, there is nobody has addressed us on the issue that suppose the state 2014, state 2012 primary teacher appointment, you find a nagging indication to the effect that there has been transference of money, there had been a money trail, there had been a scam, there had been arrests, but nobody of you have argued this, that where does that link us? Suppose in education, in education, suppose there are 5 consecutive investigations going on.
Correct.
One upper primary, one primary,
Correct.
one lower primary, whatever it is.
Correct.
So, as constitutional court is looking into the matter in the backdrop of the corrupt procedures which has seeped inside our education system.
Correct.
But nobody has argued us that suppose you conduct an examination.
Yes.
My brother and myself are participants in that.
Yes.
You realize after the examination that there were 1 lakh candidates and there was a large scale corruption or scam, whatever you describe.
True.
But if I am there, you have to link me with that corruption. Then the analogy comes of the illegal beneficiaries or the persons who have illegally, suppose a person has given a certain amount of money to certain person, and on the backdrop of that he has got the appointment. But it is, how do you establish it?
May I say this?
One is that there is direct evidence linking me to that offense. That yes, I have given bribe.
Yes.
And the another is the perspective which you are arguing.
Yes.
You have repeatedly said that don't apply the perception to the perspective.
Correct.
But what more can be done? The perspective is all round corruption and scam. Then as a responsible citizen, how do you argue?
May I argue?
My lord, kindly do not drag me into that illegality because there is no evidence connected.
I understand. May I say? I have understood, my lord.
So this is the soul of the court.
Yes.
Constitutional court is seeing that 5 stages where corruption is there.
True.
Investigation is going on. CBI, CID has come into the picture.
True. May I?
How do you, suppose you were in the seat of a judge.
Yes. How I would be responding?
That's your perception. That's your perception.
Has to be.
The division court may not apply that person because we are independent human beings.
Correct.
What is wrong to you may not be wrong to me.
Absolutely.
But you cannot just cull yourself out from the regards of this perception which has led to the delivery of this judgment.
Well, may I say this? I have understood. Now, this part of the submission is not as a counsel.
But nobody has argued before us.
No.
Still, this is the
But
7th hearing.
I have understood.
Nobody has argued. Nobody has argued that there is not a scrap of paper to establish that I had given bribe to obtain the appointment.
May I say this? Well, this part of the argument submission has got nothing to do with appearing as a.
No, that is on the. No, Mr. Bandyopadhyay. It has been argued what? That Mr. Dotto has proceeded on the definition of corruption. That what is corruption?
On facts and figures, like you did.
Just hypothetically imagine a situation. No. Why we have said hypothetically you imagine a situation. Today an investigation is going on. Tomorrow say the investigation attains finality and it is found that the person who have taken, there is direct evidence and they are guilty of this thing.
May I?
there is a criminal investigation will entertain despite the institution having no legal right, and court will not examine because this is a read court, not as a PIL court.
Court has, it is not a, you are going into, you are not independently viewing the matter. The answer which we are wanting.
ওই জায়গাটাই বলতে চাইছিলাম যে একটা ছোট্ট একটা লাইনে বলতে হবে।
From the aftermath of the case, 2014 the case, the recruitment process of 2016.
May I,
that we have,
I have, this part has got nothing to do with my clients, me as a counsel, I'm saying, because whatever I think. Well, I'm continuing where Lordship ended. In the entire environment, when the entire environment is polluted, what to do? That's precisely. We have now the perspective of 26,000 gone. I'm saying the
no, we
SSC
are not
case.
concerned.
I'm saying the other. So the environment. So far as this case is concerned, there is a reference of the word CBI investigation. Lordships are aware that every recruitment processes are separate. Like I have to pass state. Assume I have passed state in 2014. Does not mean I will only participate in 2014 or 15 recruitment. Once I am TET passed, it's a prerequisite. Then I can participate in any. Yes, Mr. Bandyopadhyay has said that. So what I'm trying to say, in the end,
stepping stone.
In the end,
apply that TET only, not only for this, the training qualification will remain with the TET eligibility criteria.
Yes.
It specifies 15 marks in a selection process, as in this case.
Yes. No, what I'm saying is that so far as any allegations of the TET, Lordship will not find anything, any paragraph being dedicated anywhere in the judgment, not in the writ petitions, nowhere. Today, before your Lordship, I could have understood there are situations where Lordships have to enter into. And there are situations where Lordships are not required to enter into. In my humble understanding, Lordships are not required into the environment aspect of, as Lordship was expressing, I'm saying metaphorically, based on the writ petitions, affidavits, pleadings. This is a case.
You leave it untouched.
Yes. Why? Well, I say why. There is a reason for that. Why? Reason being, in the entire writ petition, Lordship will not find enough materials.
Yes, that you have, that has been shown to us.
And only tilting factor, I could have understood that Lordship feels that every part of the evidence, every part of the marking, whatever learned single judge has said, that is correct. But there is a likelihood that Lordship may feel that that was a perception of the Honorable Single Judge. Huge, as I said. The marking taking from the para-teacher. So therefore, if Lordship picks up 4 or 5 points of the entire judgment, Lordship will find each of the judgments actually false. Sorry, each of the logic in the judgment actually false. It doesn't stand. It can only stand if someone looks at the issue based on an incorrect facts. For an example, if truly the para-teacher, that marks had been the last marks for everyone, then learned judge is right. For an example, this 12%, if it is found to be something for the first time, any examination this has happened, then in every examination out of 100 persons, 100 of them should be academically better. But this is not. So,
all right, thank you, Mr. Sir.
But there is a portion, this part I will not make any submission. As point number 7. Only because but I'm relying on this, my lord, the judgments I have given on the point that when they are filing after 4 years, 5 years,
They ought to have made us a part.
so the necessary party, I've given the judgments, why it should be dismissed. I'm not reading out. The citations for my learned friends, it is AII 1963, SC 786, paragraph 9. And the 2014 16 SCC 187, paragraph 4, where ought to have been dismissed that point. And then followed also in 2022 SCC Online SC 1307. 14, 16 SCC 187, paragraph 4, 22 SCC Online SC 1307. And I just added Rule 12, the validity of the panel, 1 year, thereafter 6 months, then 6 months. So I was trying to, my lord, look at from the perspective of the writ petitioners, that yes, it is a case which has been filed during the validity of the...
On the validity of the panel was not even published.
There is no requirement of publishing in...
So
law doesn't require
how come
it.
you take this point? There is no definition of publish.
It was on the website. It was all
But the definition.
all these documents, all these markings, they have all the calculations of 14 marks and everything, all they have obtained from the website itself.
No. Your their contention had been there was no publication of the panel. If that
They are absolutely right. There was no publication of the panel in a sense that the entire panel being published, but the names of the candidates with the breakup marks who have been successful, all were put on the website.
that is subsequently. That is subsequent to the writ petition, na? As called for
I will
by
answer to Mr. Dhar, my lord. Your lordship, kindly, my lord, give me permission, my lord. I'll answer to my learned senior friend, my lord.
You
So
take
far, your
note of
lordship.
that. You
Yes,
take
yes, I've
note of
taken.
that. We will be asking you.
On a pure point of law, lordship will not find.
Kindly come to the definition of panel. Panel definition means a list of names of eligible and selected candidates for appointment as teacher in primary school published by the board. And Nihar Ranjan বিশ্বাস, you are good in front of me.
Yes, my lord.
This publication.
Oh, that
publication where?
What is
so the word publish is not there under the rules. But that has been drawn by them. They have argued that you see these definitions, so publication is mandatory, which is publication issue was not there.
True.
Now the board's counter statement was that everything breakup and everything the single
There.
judge has called for.
My contention is only this.
Yes.
No one is perfect. We learn, rectify, move on. There are certain things which cannot be rectified and that has to go. No one is perfect. Assume intelligent. He doesn't deserve to become a teacher because...
That is because you have no answer for that.
No, not for that. Someone having, after participating, he will simply go for a hibernation. He will sleep.
Yes.
Even today, lordship will see, we get all the orders from the Honorable High Courts.
So you mean to say it was their obligation?
I say this, may I say this?
It is not the obligation.
I say that one thing in a different angle can look something different. I say that there is a gradual improvement in the entire process. Like today in every selection process, they are trying to be more transparent. But there was a time when there might have been some, I do say, it was not as perfect that as required to be, in a sense that every part of it has to be transparent. But this is a process, my lord, going on. Now, once informations were taken by the Honorable Court, and it was also thereafter put on the website, when that is checked up, and that is found to be in order, there, after 5 years, because lordships are also, when writ petitioners have come, absolutely fine. But simultaneously, the other side, kindly take an example of this. I know this is nothing to do with law. Because I got that job in 2017, because the same honorable judge also passed another order, whoever has got the job in 2017, this recruitment process, they will not be able to participate in further recruitment processes. And the board acted that. So once I got the job, I am working, I am surviving, my family is surviving, I am not able to participate in other recruitment process. 4 years have gone. Now to look back would be too much of things required. All I'm trying to say. I don't say absolutely big no, but their requirement has to be so many things which are absent in the writ petitions or the pleadings or in the basic facts of the Honorable Single Judge.
Yes. So that is what Mr. Mitra was saying, no? That if today they have only, if you give them the job, they will not challenge our appointment.
Because justice, my lord, what I find is justice is quite a nuanced thing. Just by termination of persons, it may look as a justice. It may look, I'm saying, because we don't live in utopia. So amount of the irregularity and corresponding whatever directions will ultimately be the very...
So for generations, persons will be taught by persons who are not competent for that thing.
This
is not a specific performance.
That formation based on fact that we are not competent has to be arrived. All I'm trying to say that the system is not perfect. I agree with that. But we deserve the system as we are. We are also not perfect. But that does not mean we are incompetent.
That is because the learned single judge reverts back the selection to the same body.
That
without earmarking that what should be the parameters of aptitude.
Now
then the same mistake will go on for generations.
Yes.
Same mistake
Yes,
will
same
go
mistake.
on. But Mr. Dhar, you cannot say, suppose you are arguing on your side, I have worked, I am in service, I will not get job. But what happens in the greater interest of justice?
Choice is not between good and bad.
How the society suffers then?
Choice is not between the lordship. I don't think it's not between the good and bad. Accepting the environment being such, choice between bad and lesser bad. My submission before your lordship would be lesser bad would be setting aside of the judgment and order of the honorable senior. That is my submission. I don't try to say that every part of it perfect. When lordship opens up and says, yes, that is there, but lordships are really not having the choices between good and bad. Because system would go on, lordship, for an example, this transparency, there can be transparency in future. But the fundamentals of saying this to be not right, those fundamentals are, my lord, mostly colored by the perception of the honorable single judge.
Thank you.
And on the validity of the panel, there are 2010 6 SSS 777, the paragraph 16, 24, 25. Now, no relief cannot be given based on Kaushik judgment, paragraph 28 also. Even today, if relief has to be given, then that 28 has to go. 2010 6 SSC 777, paragraph 16, 24, 25. And I'm not placing it. This is already, I have put in my note. And then, my lord, 24.
No legal right after panel expiry. Panel was not published.
My lord, panel was approved. Publication of
board
by the board. And thereafter appointments were given. And then the panel has a life of 1 year.
All right.
And 6 months.
Was
Rule
not-
12.
Rule?
Under Rule 12, The panel validity is for 1 year, thereafter 6 months, then 6 months. I say that you have participated, so you know that the validity is 1 year, 6 months, then 6 months, so 2 years. So within that 2 years, you did not come.
Rule 12.
Yes, Rule 12.
Approved panel. Yes. That
Kindly see first
approval
nine.
of panel was brought by them. Approval of panel documentation was there. That they
Well,
did.
kindly see 9. The panels after being prepared shall be accorded approval by the board and thereafter shall be sent to the respective district and school council with all necessary papers for appointment. So that happened pre-February 17. And then kindly come to 12. An approved panel shall remain valid normally for 1 year from the date of approval by the board, provided that the board may extend the validity of such period panel by 6 months at a time, but the total period of such extension shall not exceed for a period of 1 year. So I take it so 1 year, and then also I take it further 1 year. So 2 years.
So the when was the approval given?
That was, I believe, before February 17.
February 7.
Before 7, it could.
Appointment was in.
Appointment was in February, March.
So we can take it as February.
I take it that's why. So February 17, if Lordship adds 2 years by, then my lord, I get the benefit of this judgment. 2010 6 SSC 777, and then there is the latest also 2024 SCC online SC 1189, paragraph 10 and 30.
Yes.
And there is one more also on this point. 1996 9 SCC 309.
Please, Mr. Dhar, we would request you to on the judgments.
Compilation.
Like in 165 you said that all right, I'm relying on these 2 judgments. Only the judgments which are relying upon.
Yes.
If you can point out, because your note contains.
No, well, only. No, I have understood. Lordship may pen through here and now I can say. Well, in 165, only one judgment called Kobita.
160?
165, page 7. Can you come my note? Lordship may put a cross on that. Page 7, Roman 4 and Roman 5.
Kavita Sharma?
Yes, Kobita and Ajoy. These 2, Lordship may delete.
Others you have given?
Others. Yes. All I have given.
No, all has not been.
No,
given.
sorry.
No, can you do this? The judgments, we are giving you back the judgments.
I can prepare a compilation.
Yes.
I would be happy to do that. I shall use. Oh, that's the reason.
All right, these are the judgments here. Yes, thank you.
And well, there is just kindly give me 1 second.
30. I got it. Okay.
This is my. Well, there was a.
চ্যাটার্জির সাথে ইস্যু করে বসছে ওটা দেখে সিঙ্গেল বেঞ্চ বসে
না বাট পাবলিশ ঠিক আছে ওরা কাটি না
টুপি আছে Yes, what you're saying?
Well, there was in course of proceedings, Lordships asked one question that why they did not challenge an interim order. Lordship may kindly remember that. One of the orders by which some
Yes,
persons,
yes, yes.
why? So I was trying to find out how to defend that part of it because no answer came from this side. Fortunately, I could get a direct page 11 of my note, paragraph 15. There is a direct judgment 2009 3 SCC 250.
Paragraph 15.
No, not para. I said
that is your
my serial. Page 11, 15. This is 2009. That interim order not challenge is no consequence. Lordship, paragraph 28. Lordship, I have exactly quoted because I was thinking how to. And well, no pleadings, no prayer, no relief. There are two, like everyone knows these two judgments, VK Majorta and this Ajay Dogra, 2003, 8 SCC 40, paragraph 8. And to দিয়ে দাও, দিয়ে দিচ্ছি। ঠিক আছে। 2003 840 মানে 8 SCC 40। Well, should I give the compilation afresh?
No,
or
not required. If we find any judgments missing, we shall.
Yes. I have all. Well, this.
You have given, your junior has.
Yes.
What he has given, he knows.
Well, it is so voluminous. All of us, we are trying to get hold of all the points which can save us. So, and 2003 8 SCC 40 and then 2011 14 SCC 243. I'm relying on that, but I'm not reading it.
All right.
But my serial number 13. Well, they entirely relied. There is scope of reliance of RTI document. There, one judgment. What has happened? What they have relied on. Firstly, it was wrong, incorrect. Secondly, they have annexed couple of documents, which is their understanding based on their RTI replies. They have not annexed the RTI replies. They have only given some compilation trying to say.
So don't let them advance the argument. If required, you point
No,
it out.
only I'm saying that there is a judgment so that they can take note of that. 2021 19 SCC 396. Their High Court was not justified and had fallen into error relying on the RTI reply. In this case, our case is even better. It was not even an RTI reply. It was a compilation of RTI based on their understanding of it. Well, I shall be ending with 7th of July 2023 order, page 696.
What is this fresh selection part was set aside? What is that?
Well, I'm coming. This is, Lordship is hearing this because of the order of the Honorable Supreme Court, where I only want your Lordship's attention to be drawn out two things. One, prima facie, the Honorable Supreme Court was satisfied because of we are not even party. This part. Other part is whoever is aggrieved, who challenges the order, not whoever is sailing in the same boat of the Writ Petition Act. They can challenge it and all contentions can be taken before your Lordships. Lordship may kindly have a look at page 703.
That has been shown to us by Mr. Bandyopadhyay.
Then I don't need to.
That the persons who are wanting to challenge them can come and say.
Fresh selection part was set aside because the honorable single judge directed
That you hold the fresh
Yes,
selection.
yes,
That was
yes.
that
No,
was
first 3 months time so that they can do the training.
yes.
And then fresh selection, because now no untrained, because now the law is completely changed.
Now court said that no fresh selection should be done.
Yes.
Second part was also stayed.
Yes.
It was not set aside.
No, it was
7th of July order.
Yes, Lordship is right. Lordship is right. It was stayed.
Now why you have said fresh selection part was set aside, this bold in bold.
My reasoning is this, that the Honorable Supreme Court were fundamentally satisfied that these persons for 5 years who were working, they needed to be a parties.
Yes.
So therefore, whatever happened, good, bad, immaterial, they were not there. Like we are not there. Like today we are interpreting how the evidence went, but we are not there. We did not even get any chance, my lord, to examine, to cross-examine. When the Honorable Supreme Court gave us a chance for which we are surviving today, only that part. These are my, are deeply obliged.
How many? They have not finished. They have not yet finished.
But only one more. I have one sentence. Nothing on merit. I am appearing for in this matter, but there are some visually challenged persons. So there was a request also by them. I am adopting. There is an applications filed by the visually. All are visually challenged, and they are serving for 5 years.
Give us those appeal numbers.
Yes.
You are appealing.
Only reason that since I keep appearing for the visually challenged persons, I know them, their difficulties and every part of that. So for them, getting a job is something so big. So only adopting all the submissions I have made.
What is the number of
Yes,
that
number is
CAN 58.
CAN 58 of 25. CAN 58. Appeal, same appeal. 873.
So that can is for what?
Can for addition of party.
That has been allowed.
No, that has not been allowed. It was none of these cans have not been allowed. I make only these submissions.
Now, in any other appeal, visually handicapped are involved. In any other appeal,
in my 635, I believe there is one person who is visually challenged. Only to draw your lordship's attentions that our world.
Can will be, we are hearing everybody.
Yes.
Can will be at this stage. If visually handicapped is represented by you in this appeal also, there is a candidate.
Yes. In fact, only one thing I can say from my own experience, there was a time when government never allowed any visually challenged persons to take any job. So it is our court in a public interest litigations. I remember first time when I met them, I wanted to know how you teach. You convinced me.
That is CAN 58 or 2020?
5. For them,
অ্যাপয়েন্টমেন্ট যা হয়েছিল তার থেকে ভ্যাকেন্সি বেশি অনেক বেশি এনি কেসে সিলেকশন পুরোটা ক্যান্সেল হয়ে গেল কিনা
well, I only think for them leaving home and to reach school, that itself something possibly we cannot think of that they have to go through. Only to, I know
How many handicapped persons are there?
there are 7, but I want your lordships to take note of all.
So this 32,000 includes physically handicapped also.
Yes.
But in any case, they are protected. And why I am submitting so much? Actual vacancy of the physically handicapped. For example, it was 100 vacancy. Only 30 physically handicapped persons were appointed. In any case, they are protected, madam. That's my understanding.
No, this 32,000 was 36 was changed only or mentioning
Yes,
only.
madam. Yes, madam. Why? Numbers were not clear. Even today, the numbers is not clear. 42,000 and odd. Out of them, 11,000 and odd were trained. Rest were untrained. Why I differentiate between trained and untrained? There is a reason, madam. Aptitude test, for example, as trained candidate.
No. Suppose, do you understand the 36,000 to 32,000? What happens to those 4,000?
4,000.
Today I am satisfied. I have not been sent out. Tomorrow morning I find my job has got.
Main crux of the matter was untrained, madam. Crux was trained and untrained. When it was trained and untrained, what happened, madam? There are two categories. One trained and another untrained. For example, if a trained candidate, even if he gets 0 in Viva and aptitude test, he would have been appointed. For training, the marks was 15.
No, we are not on the trained portion. We are only
Untrained portion. Yes, we are on the untrained portion.
That 15 marks goes.
15 marks goes. For there are roughly 32,000 candidates in the untrained category. That was principle. I filed the application, filed a writ petition, and subsequent application, subsequent documents were filed in respect of those candidates. In my writ petition, my lord, I have categorically stated what are the problems, what are the issues. Subsequently, and a question came to why I didn't raise the question of aptitude test at the time of filing writ petition. And problem is that on September 2022, writ petition was filed. For the first time, one breakup of score of empanel candidate came in the light on 28 November 2022, much after filing of the writ petition. I came to know that a number has.
That is how you explained your delay.
Another thing is there, my lord. The one thing, submission is being made.
We will hear.
A submission is being made with the reckoning panel expired in 2018, but from the document filed before in this matter, appearing in the paper book 1, I can show the appointments were made in 2020, even from this particular recruitment process. That is on record. There are 11 additional panels, and out of how 11 additional panels were made, no one knows.
That is the subject matter of challenge. Then anyway, 36.
No.
And it's
First limb of argument was the trial court has proceeded on a wrong premise that we are untrained. Because of the advertisement requirement of the advertisement and the statutory notification. Within 2 years, one has to be trained, which we have completed. Therefore, that is the first argument that the learned trial court has proceeded on a wrong premise.
No. You are untrained. But upon appointment, you have completed the period as prescribed under.
Correct. Absolutely.
That was your.
That's right. And that has been permitted. That is permitted under the statute. And if I was
No,
appointed, I
that
would have
point
got
has
20.
not been, I don't know whether they will take that point. The 6-3 application and your appointment and completion, that is not disputed.
Not disputed, but the learned trial court has proceeded that we are treating as untrained, ignoring that notification. That's why I'm telling you.
They themselves have said that
No,
you
no,
are,
no, no, no.
you're
If
coming
that,
on that.
anyway, reply, I will get chance. I will show.
I shall satisfy your lordship.
I will, in reply, I will get chance. I'll show.
Board in their obituary.
On Friday, hopefully, you will be concluding your part. We have
But in any event, I have prepared a one-page note along with 3 judgments. I will not be taking more than 15 minutes of my time. Sir, I don't want to make any repetition.
If he takes 15 minutes, you are half an hour, we can conclude. The thing we are not being able to tell you is that let their arguments come so that I can seek answers. We can seek answers from it. Unless no, not 1 or 2 days.
I will be taking 15 minutes.
So we thought Mr. Dhar would complete it within 1 hour. We thought Mr. Dhar would complete, but he also has to make his submissions. This way, if the time goes, so we are requesting.